It's on item 52 losses. In case I supposed to file a reply, but I'm unable to contact the petitioner for last 2-3 months. I think 52. There is the IA also. I take the concept from the opposite side with an unable to contact the petitioner.
You're for the applicant
I'm not the applicant.
and the writ petitioner.
I take several proposals, take times also, but unable to contact the petitioners.
Hmm.
Yesterday also, link that they have not received my phone also.
So how much time do you want?
After 2 weeks,
Let's
I have not unable to contact the petitioners.
As paid for by the line counsel for the petitioner. This is the matter again after 2 weeks. On a date 2 weeks by the petition.
May please, Your Lordship. I recommend item number 4, Lordship. We already filed adjournment slip yesterday, Lordship. Maybe least after 1 week, Lordship.
Okay, as paid for by the line counsel for the petitioner. Matter stands adjourned for 1 week.
Lordship. Another prayer, Lordship. Item number 26, 27, and 28, Lordship. We may be withdraw, Lordship. Matter become intersected, Lordship. We filed an transfer petition before FX court, Lordship, and petitioner got relief, Lordship.
Which one?
Item number 26, 27, and 28, Lordship.
What is your name?
S. Hussain, Lordship.
Mr. S. Hussain, learned counsel for the petitioner. Submits that the petitioners would not like to press the writ petition. And therefore he permits that he submits that he may be allowed to withdraw the writ petition. Anyone? Mr. S. Sutia, learned standing counsel, elementary education department. Appears for the State Department and has no objection. In view of above, the writ petition stands dismissed as withdrawn. 27, 26, 27, 28. Same order.
Right, Your Lordship.
Oh, one more thing. I think there might be an IA also. Pending IAs are also disposed of in view of the order passing the amended petition. Huh? You just see whether it's pending, then you can. Yes.
I would to mention item number 12 and for the petition also. Therefore, pass was something like that.
Okay, item 12, as paid for by the learned counsel for the petitioner. Matter stands passed over for the petitioner. Petitioners.
This matter come up. There is a content matter pending. This along with content number.
Which one?
382.
Which one?
This matter not listed. Pending.
Huh?
Petition maybe come up. Item number 12. Come up.
So why don't you say so? Why are you mentioning in piecemeal?
That's it.
You want Passover, then you want it to be listed again with contempt.
Yes, sir.
Which contempt?
Content number 382 only 25. By the same petition.
382
Yes, sir.
of 2025.
Yes, sir.
Is the matter again after a week on date to be fixed by the registry along with the contempt case C number 382 of 2025.
Lots. Deep levels.
May I please, Your Lordship, I want to mention regarding listing of 2 read petition, one of 2023 and one of 2024, Lordship. Both the matter relates to family pension.
Yeah.
Next week on Wednesday and on Friday.
Please approach the registry for that. Okay.
I'm sorry.
Please approach the registry for listing.
Wait, please.
Yes.
Let's mention item number 31 also with the consent of other side.
13.
31 Lordship.
What do you want?
After 2 weeks, Lordship. After 2 weeks.
You're for the petitioner.
Lordship.
As paid for by the learned counsel for the petitioner. Matter stands adjourned for 2 weeks. Yes.
May I please, Lordship? Item number 23. My senior is going through some health issue. Kindly fix it on another day.
23.
Yes, Lordship.
Who's your senior?
IC Deka, Lordship.
Mr. IC Data, learned counsel for the petitioner. Is said to be in this post. Stop. On a prayer made on his behalf. Matter stands adjourned for 2 weeks. Yes. Next.
Paying for listing on any date in the next week, Lordship, I had approached the registry. There is a register where pieces which are to be listed can be written. I had written that about a month ago, but it has not been listed.
Remind them again. They must have forgotten it. Please approach.
The registered, it's already written. So
Hmm?
this matter was last listed in November 23, Lordship. One seat
Hmm.
is kept on hold as an interim order in this case, Lord. So I'm saying that it may be listed in the next week.
No, you approach the registry again. Where did you write in the register?
About a month ago, Lord.
No, no, take it up again. You must have forgotten about it. Approach them again. Okay. Yes.
My lord, I beg to mention item number 55, 56, my lord. Matter may taken up at 2, my lord. It was on last occasion, my lord, prayed, my lord, but on that day, it was directed to be mentioned, my lord.
Okay, at 2 p.m. 2026.
Oblige.
May I please, Lordship? In this matter, my lord, we are supposed to file an additional affidavit, my lord. We have filed only yesterday. It is not in the record. The matter will come in the next week, my lord. Along with the affidavit, yeah, filed yesterday.
What affidavit is this?
An additional affidavit, my lord.
Okay, counsel for the petitioner submits that an additional affidavit was filed by the petitioner, but the same has not come up with the record. Stop registry to verify and connect the same to the record and list the matter again after a week on a date fixed by it.
That's outline.
Wait, please, Lord. Sorry, Lord. Item 2, Lord. Matter relates to compassionate appointment.
Oh.
Petitioner approach earlier, Lordship. Page 20, start from page 20, Lordship. Relevant page 23, Lordship, last para.
Breathe.
In view of the above, this writ petition will now stand disposed of with the direction to the respondent to consider the case of the petitioner for appointment on compassionate ground within a period of 3 months from the date of receipt of this order or a certified copy thereof. The case of the petitioner will be considered by the authority in terms of his claimed eligibility along with other similarly situated persons and subject to availability of post against the earmarked quota for compassionate appointment, Lordship.
Yes.
Thereafter, DLC recommended, Lordship, page
DLC,
32.
DLC recommended.
Yes, Lordship. Page start from page 32, Lordship, and relevant page 33, Lordship.
Yes.
Page 33,
Hmm.
down below, box, Lordship. Serial number 1, petitioner.
Golam Zakaria.
Yes, Lordship. Remarks, Lordship. The deceased employee died on so-and-so and applicant submitted application on so-and-so. However, as per court order, WBC number so-and-so annexer so-and-so, it is directed to consider the case of the petitioner for appointment to compassionate ground. It is further directed that the case of the petitioner will be considered by the authority in terms of claim eligibility and subject to availability of post against the earmarked quota for compassionate appointment. Hence, on the basis of court order and availability of vacancy, the case may be recommended to SLC for consideration of appointment on compassionate ground, Lordship. Thereafter, till that, Lordship, SLC has not placed my application, Lordship.
You are there?
Lordship, Mr. Air coupon is on legs at port number 1, Lordship. Matter may be taken after some time.
Who is the counsel?
Mr. Air coupon, Lordship.
Air
Standing counsel.
Okay.
elementary.
Okay, you wait for some time.
Right, stop.
Ambi.
Pleasure of it. In this case, the petitioner was a teacher and he pursued B.Ed course as per advice of the government in the under their policy. So after passing of the B.Ed lordship, he was entitled for one advance increment, but that was not paid. That is the case. So the lordship, there is some similar order of this honorable court also. It is the next I.
Why increment is not given to you?
Lordship, there is no justification. I have submitted representation also, but I have not received that.
Where's the policy of
As per
getting one increment?
So it is Assam Service ROP rules 2017. Lordship.
In the writ petition, have you incorporated any provision by which you are supposed to get one increment?
Lordship, that provision I have not enforced.
Then why have you
Assam
filed this
Service
writ petition
ROP
then?
Assam Service ROP rules 2017 is there also.
When you don't have the ingredients in a writ petition, why have you filed it? You should be able to show me in the writ petition, this is the provision. I should get one increment. Where is that? The very basis of your claim is not available in the writ petition, then how do you?
Representation has been sent to the concerned authority, your lordship. There is no representation
Lordship,
given by the petitioner to the concerned authority.
SP Das, I'm asking him, please don't interrupt. This is his writ petition.
I shall
Let him move his writ
I shall
petition.
submit additional affidavit, Lordship, with those facts. Lordship.
Where is the provision? Under what provision is that?
Lordship, under the Assam Service ROP rules 2017 is there, Lordship, but that rule is not available with me right now. So I shall bring it and I shall furnish the necessary provision in an additional affidavit, Lordship.
Why did you file the writ petition like that? No? You think everybody knows that it is an accepted position that everybody knows that if you pass B.Ed, you'll get one increment. Incorporated as paid for by the land council for the petitioner, matter stands adjourned for a week to enable him to file an additional affidavit, incorporating the provisions under which he claims to get the benefit of one increment on passing B.Ed.
I'm appearing to respondent
Ms. P. Das Lanet,
4.
standing counsel appears for the department. Next.
So in next I, there is a covered judgment, Lordship.
Covered judgment will not do. Give me the provision.
Maybe, Golos.
Yes.
This petition has been filed, my lord, seeking, my lord, compassionate upon me. The petitioner has filed an application before the DLC, my lord. Simple prayer, my lord, this,
What is your prayer?
my lord, the application which has been filed by the petitioner before the, my lord, concerned authority. Can be disposed of on merits.
No, it's not like that. Then you go there. You don't file writ petition just to get one order from the court disposed. This is not post office. Tell me what is your case?
Now, the father of the petitioner, my lord, died in 2016, my lord. Your lordship may kindly see, my lord, page number 17, and example 7, my lord. This is the death certificate, my lord.
Okay, just a minute. I think you have missed the bus. You have missed the bus.
Understand the situation, my lord.
You understand, then you withdraw or I'll dismiss it.
2016.
It's 2017 notification.
Now, at the time that notification was available,
I'm dismissing it.
Then in that case, I am withdrawing the same.
Okay, as paid for by the learned counsel for the petitioner, Mr. A. Talukdar. The writ petition stands dismissed as withdrawn.
I'm appearing for
Ms. P. Das,
secondary
learned
education. Your Lordship.
standing counsel, secondary education appears for the State Department.
Respondent 1, 2, 3.
Hmm.
I'm deeply obliged.
Yes, next. Yes, Mr. Hukant. See, I'll just tell you briefly. Long time back in 2002, petitioner filed writ petition, compassionate appointment. Court said that, okay, considering within 3 months. That 3 months came only in 2021. DLC met on 21/12/2021 and recommended his name to be forwarded to SLC. Now, since he's not forwarded, he's come before this court. What is to be done?
This case, my lord, he's come so late, my lord. So therefore, my lord, perhaps one of the.
No, he's come so late, but even the DLC has also sat so late.
Yes, my lord.
What is to be done?
We will give, we'll dispose of the matter then and direct, my lord, the department as well as the deputy commissioner office, my lord, to basically
Let them forward.
let them go through it, my lord, and if they see any merit, my lord, then they may reject or they may consider.
No. The SLC has already, the DLC has already recommended. Page 33.
My lord, the government will be the appropriate, sorry,
Okay, government. Who's appearing for the government?
government will be the appropriate authority.
DD Burman. So one more time being, okay?
May I please your lordship? I request your lordship to kindly fix this matter for time being. As my senior is on its way to this meeting. Item
6 also time being.
problem.
May I please your lordship?
Yes.
My lord, this petitioner has retired as principal of Nirmal Alloy College, Patasar, Borpeta on last 31/1/24, my lord. He has not received his GPF amount, leave encashment amount and group insurance amount, my lord.
When did he retire?
He retired on 31st January 2024
As in the position of
as position of principal of the college.
principal of Nirmal Alloy College,
Patasar. It is in Borpeta district.
Patachar Kuchi, Borpeta district. Yes, notice. Short date,
Third day.
short date. Your good name?
AC Sharma.
Part Mr. A.C. Sharma, learned counsel for the petitioner who submits that the petitioner retired as principal of Nirmal Alloy College, Patachar Kuchi in the district of Barpeta on superannuation on 31/1/2024. To stop, despite the same, he has not received till date his GPF, leave encashment and GIS money. What about the pension? Pension you received
Pension and gratuity has been paid.
till date. The petitioner has otherwise received his pension and gratuity. Next, para, in view of above, issue notice of motion returnable by 3 weeks. Mr.
Yes, yeah.
S. Bhuya, learned standing counsel,
I do this for one and two also.
higher education, accepts notice on behalf of respondent numbers 1 and 2. Who else is there?
I am appearing for respondent number 3 on behalf of Mr. S.K.
Mr. S.K. Mehdi, learned counsel appears for AG Assam. Representing respondent number 3. Then who else? Okay, petitioner to take steps for service of notice upon the respondent numbers 4 and 5 by registered post with AD due within 3 days. To list the matter again after 3 weeks. Respondents to come up with instructions or counter affidavit by then.
Okay.
One more thing, right? List again after 3 weeks, is it? On a date to be fixed by the registry. One more line. Pendency of the writ petition shall not bar the respondents to release the dues of the petitioner in accordance with law. Yes,
Well, in this case, my lord, petitioner was initially appointed on compassionate ground, my lord, in grade 4 post, my lord. As he was eligible at the relevant point of time, my lord, after the death of his father, my lord, he has applied for, my lord, any post grade 3 or grade 4, my lord. But subsequently, as there was no vacancy there in the grade 3 post, my lord, he was appointed in the grade 4 post. Subsequently, my lord, he is communicating with the authority, my lord, by submitting application, etc. But as there was one vacant post after, my lord, 12 years, 10 years of service, my lord, he, my lord, filed one writ petition before this honorable court. And this, as the post was, my lord, knitting and embroidery, that was one vacant post there at that relevant point of time. As he was eligible, he has, my lord, filed one writ petition before this honorable court. And this honorable court, my lord,
knitting and embroidery.
knitting and embroidery, my lord.
You know how to knit?
Yes, my lord.
Do you know how to knit?
Yes, my lord.
Embroidery.
Embroidery and knitting, my lord. He has the education qualification. I have annexed all papers, my lord. Anyway, subsequently, my lord, what has happened in 2011, my lord, after his appointment in India in 1997, this order was passed in this honorable court, my lord, page 32, my lord. The case of the petitioner is that having regard to the educational qualification, he is entitled to get promotion to the post of included in grade 3 cadre. He has specifically mentioned the post of knitting and embroidery. On the other hand, it is stand of the respondents that in the recruitment rules, there is no provision for promotion. The petitioner has referred to the correspondence made by the departmental authorities in his favor. Had Mr. Swanso, land counsel for the petitioner as well as Swanso, the writ petition is disposed of, providing that the respondents may deal with the matter appropriately in accordance with law. Subsequently, my lord, as he applied for, my lord, one letter was issued by the Director of Technical Education. Next page, Annex 7, page 33, my lord. With reference to your application dated, you are hereby informed that at present there is no vacant post of junior assistant at Nagaon Polytechnic, Nagaon. Also that there is no technical vacant post as per your qualification. This is for your information only. Subsequently, my lord, what is happened, my lord? He was, my lord, transferred to, my lord, in Assam Engineering College, Jalukbari, my lord. And Jalukbari, when he was working from the year 2011, my lord, in the year 2023, he was one attachment order was, my lord, issued by the authority that this order was, my lord, he was sent back to Golpara again, my lord, from Jalukbari, Annexure 8, page 34, my lord. The service of Pranab Goswami, grade 4, Assam Engineering College, hereby attached Golpara Polytechnic, Golpara, with immediate effect. He is allowed to draw his pay and allowances from the substantive post as grade IW, Assam Engineering College, Jalukbari. Then, my lord, what is happened, my lord? As one post, my lord, was there, my lord, regarding, my lord, grade 3, my lord, he has applied for by another application in the year 2024, my lord. Annexure 9, page 36. Most respectfully, I beg to state that in spite of I have educational qualification of HSC, CTT, ITI, I have been discharging my duties in the same grade 4 post from the last 28 years. I am a grade 4 employee of Assam Engineering College, but as I am resident of Golpara, I am rendering my services here at Golpara Polytechnic on my attachment order basis. At present, I have come to know that there is vacant post of junior assistant lying vacant at Golpara Polytechnic, Golpara. Therefore, I have applied for my upgradation in the post of junior assistant. As there was one vacant post lying there, my lord, grade 3 post, he has applied for there, my lord. Subsequently, my lord, his application was also forwarded to the, my lord, Director of Technical Education, Annexure 10, page 38. Forwarding of application in respect of Pranam Goswami, grade 4 employee. I have the honor to forward herewith an application in original dated so and so, Assam Engineering College, now attached to Gwalpara Polytechnic, Gwalpara, which speaks for itself for favor of necessary action. Next page, my lord. My lord, applied for some information regarding the rule, whether he can be able to, my lord, I can be able to, my lord, promote myself, my lord, in the grade 3 post, my lord. They have, my lord, mentioned the reply, my lord, annexure 11, page 39, my lord. That the scope of promotion of grade 4 employee to grade 3 is that they should hold a graduate degree with diploma in computer application, and for grade 3 employee, the scope of promotion is that they should have rendered at least 5 years of service as junior assistant, service rule enclosed. Even if a grade 4 employee is HS pass, that means 12 pass, there is no scope for promotion to grade 3 if she has no graduate degree in any discipline from a recognized university and a diploma in computer application of 6-month duration. He has the diploma, my lord, but he has not graduation. But as rule says that, my lord, for promotional post, my lord, graduation is not required earlier, my lord. This, my lord, amended. I have annexed that he must have the computer knowledge more than 5 years is to work. So that being the position, my lord, petitioner has come again before this honorable court to ventilate his grievances, my lord.
This, just a minute, this point number 1
Yes, my lord.
is backed by which provision of law?
And that is, my lord, 2017 amendment, my lord. 167, it is, my lord. 167, it was 2017 amendment.
Education manual?
Yes, I have also annexed it.
Which book?
This book, my lord. Assam Services Manual.
And which rules?
My page 168, my lord. Assam Ministerial District Establishment Service Rule 1967.
Rule?
Rule, my lord, 6.
Sheristadar.
Yes, my lord. Rule 7, my lord. Sorry, my lord. Page 176. Condition of eligibility. In order to, my lord, to be eligible for competing in the examination for appointment as junior assistant, a candidate must satisfy the following condition. At rule, my lord, number 3, my lord, educational qualification.
You want to sit for exam?
Lordship?
You want to sit for exams?
No, my lord. He is praying for promotion, not educational qualification. For his promotion.
But what you're reading is exam. In order to be eligible for competing in the examination. Competing in the examination means what?
My lord, Assam Ministerial District Establishment Service Rule 1967.
Correct. You are
Yes,
reading rule 7.
7, my lord.
So you are talking about examination.
Yeah, for my lord, recruitment or promotion, my lord. Earlier, my lord, I have also annexed here, my lord, the provision, my lord. Shall I see your lordship? In my repetition, page that is, my lord, page.
No, not your repetition. Show me the rules wherein this point number 1 has been cited here. They should hold graduate degree with diploma in computer
Yes, my lord.
application and have at least 5 years of service.
My lord, that has been amended, my lord, subsequently. Earlier, my lord, the rule was, my lord, for promotion, my lord, he has to, my lord, I have annexed page 41, page 41.
I'm just looking at the rules. The rules which you are relying upon is not relevant.
Yes, my lord. That after amendment, it is.
It's not relevant, then why are you showing me this thing?
Rule 2 says page 41, my lord. And it starts from, my lord, earlier that was rule, my lord, 4. page 41, it is said that for the purpose of promotion of deputy commissioner shall prepare a list at the beginning of each year into account the number of vacancies likely to occur during the year in question. The deputy commissioner shall associate sub-divisional officer and sub-deputy collector in selection. The criteria for selection shall be on the basis of seniority cum merit, junior assistant, by direct recruitment on the basis of the competitive examination to be conducted by the deputy commissioner at the beginning of each year, unless otherwise directed by the government in this behalf. At the beginning of the next matter rule.
See, Mr. Das,
Lordship.
your case is that you were appointed on compassionate basis.
Yes, madam.
Since there was no grade 3 post available,
At the relevant.
you were offered grade 4 post.
Yes, madam.
You have taken it.
Yet again, in
You have-
97.
You have accepted it.
Accepted.
And today, what do you say? That you should be adjusted against grade 3 post?
Yes, madam. After.
How? How?
For promotion. For promotion, not direct.
Where is the provision for promotion? Show me that.
Yes, ma'am. That is why, my lord, earlier, my lord, occasion, my lord, when we filed repetition, that was an application was also forwarded. In earlier order also, my lord, that was there, my lord.
No, I just want the provision, that's all. Show me the provision. This is the criteria for promotion.
Yes, my lord. They have annexed here, my lord. Page, my lord, notification says, my lord, page annexer 14, my lord. Page 45. Last page. Amendment of Rule 6. After, my lord, Rule 6 amendment, it is, they say that, my lord, page 46, after clause 6, the following new clauses shall be inserted, namely the candidate for the post of junior assistant must possess knowledge of computer as specified below. He must have good working knowledge of the office productivity software tools independent of any operating system, MS Windows, Linux, MS, etc., such as word processor, spreadsheet, presentation of graphics, concept of database, internet, email. He must possess a minimum 6-month diploma in computer application knowledge from an institute recognized by the government.
You are aspiring for promotion to the post of junior assistant
Yes, my lord.
by way of direct recruitment,
Yes, my lord. Because
not
yes,
promotion.
promotion. I want, my lord, by way of promotion. My
You
lord,
want promotion or direct recruitment? Which one?
promotion, my lord.
This provision you showed me is for direct recruitment.
Yes, my lord. Earlier, my lord, that portion is not here.
Where is the provision for promotion?
Page 41. That is not amended. Page 41 B, clause B. By selection on the basis of seniority cum merit from amongst the grade 4 staff of the district establishment concerned who have passed the HSLC certificate or equivalent examination and have rendered at least 7 years of continuous service in the district establishment. The portion of vacancies to be filled up in any year in according to clause A and B. So, my lord, appointment by selection.
What is this rule?
The date rule is, my lord, Assam Ministerial Establishment Act 1967, my lord. That is not specifically, it is now. 160, mention, my lord. 167.
From where did you get this rule? Page 41.
Yes, my lord, they have, my lord, when I applied for RTI information, then they have enclosed here, my lord, along with my RTI letter, my lord, reply. These are the provision.
No, you don't require RTI
Yes, my lord.
to get a copy of the rules. Rules are available. It's
Available.
gazetted. Available everywhere.
Yes, my lord.
You don't need RTI for that. Now, from where you're saying this page 41,
Yes.
this is a part of the Assam Services Manual General rules. Note 1, note 2. It is here. You have that manual with you.
Yes, my lord.
You come to rule 6. Rule 6 is recruitment.
Yes, my lord.
And you go forward, then you have note 1, note 2. Then there is one clause B, 6B.
Yes, my lord.
Have you got it?
Yes.
So this is the provision.
Yes, my lord.
Just read. By selection.
Junior assistant.
No, but it starts with by selection. Clause B, small b.
Yes, by selection. On the basis of seniority come merit from amongst grade 4 staff of the district establishment concerned who have passed the SSLC.
No, who has passed degree examination. Your book is which edition? Hmm? Your book is which edition? It's 2021 edition.
Oh, by selection, yes, my lord. By selection on the basis of seniority come merit from amongst grade 4 staff of the district establishment concerned who have passed the degree examination in any discipline from a recognized university or any examination declared equivalent thereto and have rendered at least 7 years of continuous service in the
District
establishment on the first day of year in which selection is made. The portion of vacancies to be filled up in any year according to clause A and B. Yes, my lord.
What is this 90:10? 90 is direct. 10 is promotion.
Yes, my lord. 10 is promotion.
So you can aspire to be considered under this provision,
Yes, my lord.
isn't it?
Yes, my lord. Let's notice may go first.
How many years service you have had?
28 years, my lord.
What is your qualification?
Yes, my lord. I have annexed here.
What is your qualification? Just tell me.
High secondary pass along with the all diploma, my lord.
High secondary pass is not relevant now. It's graduate.
Now, my lord, it is there, but at the relevant point of as it was at the relevant point of time, they have also forwarded. That's why. my lord.
That part is gone already now. You cannot go back.
But this, my lord, this computer knowledge and etc. certificates are there, my lord.
That is there, but you don't have
Yes.
graduation. So you're not eligible.
My lord, and my lord, so far, my lord, high secondary, apart from the, my lord, trade certificate, high secondary pass, my lord, computer knowledge, my lord, national certificate of modular employees, all certificates I have annexed here, my lord.
Okay, fine.
Yes.
All the certificates are good, but it does not add up to graduation. You need to be a graduate. This is as per the amendment. If you
Yes,
see
madam.
that same book again, it's substituted. Where's that? One, substitute the words high school leaving certificate or equivalent exam, white notification dated 15/10/2015. The qualification of having graduation is a must
Yes, my lord.
from 15/10/2015.
Yes, my lord.
Now you're coming in 2025 and saying that consider me. I've got HSSLC +2. You're not qualified.
No, otherwise, my lord, he on the basis of experience, my lord, from of his service, my lord, computer knowledge. Earlier also
Where
he-
does the rule say that if you have experience, it'll be waived? If you have all the experience and diploma certificate, graduation is not necessary. Does it say like that? It does not say. Mr. Das, you don't have a case. I'm sorry.
My lord, then my lord, simple notice may go, my lord. Other authority,
For what? When you don't have a case, simple notice for what?
because my lord, other my lord, qualifications, other parts are also
No,
here,
no,
my lord.
No. You will dismiss it
Then
just now.
I may take instruction, my
You'll
lord.
dismiss it just now.
Day after tomorrow, my lord.
No, if you take instruction also, you'll not get graduation in 2 days. Not possible. Isn't it?
Rule is very clear, Manoj, regarding qualification.
Is there something which I don't know?
No, that is the position.
The rule says graduation
Graduation is-
since 2015. Petitioner is only +2
Another
and
fact.
lot of diploma, computer and all that experience is there.
Yes.
Experience is there.
Experience
But
is there,
but that
qualification-
graduation degree is a must. Is there any provision which says that it can be relaxed? Any provision?
No.
Then
Qualification. Only age can be relaxed, my lord.
heard Mr. H. Das, learned counsel for the petitioner, who submits that the petitioner was appointed in
After
a,
some time, my lord, I have to take instruction, my lord, client. After some time, my lord.
I am recording something,
Yes, yes.
was appointed in a grade 4 post on compassionate basis on 29/9/1997. Since grade 3 post was not available at the relevant time. Subsequently, when he came to know that there was a grade 3 post available, he represented before the respondent authorities for considering him. But however, as he was not considered, he filed WPC number 6119 of 2007 before this court. So the writ petition was disposed of, white order dated 7/3/2011. With an observation that the respondent authorities may deal with the matter appropriately in accordance with law. So despite the same, since the petitioner has not been considered for promotion to the grade 3 post, he is again before this court. Next para. Rule 6. Bracket 6. Bracket small b. Of the Assam Ministerial District Establishment Service Rules, 1967, provides that the post of junior assistant can be filled up by selection on the basis of seniority cum merit from amongst grade 4 staff of the district establishment who have passed degree examination in any discipline from a recognized university. Or any examination declared to be equivalent and should have rendered 7 years of continuous service in the district administration establishment on the first day of the year in which selection is made. Stop. The proportion of vacancy is to be filled in the ratio of 90:10. That is direct recruitment and promotion. Stop. The requirement of having degree examination pass certificate has been introduced, white notification dated 15/10/2015. Stop. Mr. H. Das, learned counsel for the petitioner, fairly admits that the petitioner is not a degree holder and has passed 10+2. Stop. It therefore appears that as per the said provision, the petitioner is not eligible to be considered for promotion for want of requisite qualification. The disposal of, there's no point.
After 28 years, my lord, from the beginning also, my lord, he was starting, or trying, my lord.
I understand, but there's no other way. Considering the above, it appears that there's no writ merit in the writ petition, and according to the matter, the writ petition stands dismissed. Mr. H. Das, S. Das, learned standing counsel, higher education appears for the higher education department.
Very please, your lordship.
Yes,
My lord, this matter is regarding the constitution of a SMDC of a high school, my lord. And this is the third round of litigation. Earlier, my lord,
SMDC
The-
means? SMDC means?
school
Or
management.
School Management
And Development Committee,
and Development Committee,
Committee.
okay. High school,
a high school, my lord. So,
True.
my lord, initially, my lord, the petitioner before the lordship and another persons were nominated as president and vice president. And that was put under challenge before this honorable court. And ultimately, this honorable court has quashed the nomination and sent it back to the authority concerned, my lord, to constitute the same president and secretary in accordance with the direction and also the notification given by the government. Then the second time also, my lord, they have, my lord, nominated the president and vice president in violation of the notifications, my lord. Again, my lord, the second time, my lord, the matter was brought to this honorable court. And this honorable court then passed the order, my lord, and without, my lord, spending so much time, my lord, just I am relying on, my lord, page 50, my lord.
this is the second time,
Second time, this is the third time, my lord.
third time.
My lord. Second time, my lord, page 50.
Where-
Again, my
where-
lord, the matter was remanded.
Where's the first time?
First time,
Have you annexed it?
yes, my lord.
Please show me that. Is it page 35?
Yes, ma'am. And SRE, my lord, page 33. Page 33 and the relevant portion, my lord. Relevant portion, my lord, page 36, my lord.
Okay,
And 37, my lord, the concluding part,
30.
37. This is the first time, my lord.
Index to vulnerability, sir.
Oh, when you gave.
Index vulnerability, sir.
Yes, my lord.
Matter was remanded back, then what happened after that?
Then, my lord, next page, my lord, page 38.
Hmm.
After remand, my lord, this order came, my lord. This second
Yes.
time nomination has been made, my lord.
Who has been nominated?
Here, my lord, the one,
Hafizur Rahman.
yes, Hafizur Rahman. Now
President
the
and
present-
Abdul Kalam is vice president.
Yes, my lord. The Hafizur Rahman is now before your lordship, my lord.
Okay.
Then they were nominated second
So,
time.
so what is the grievance then?
And then, my lord, the other party, my lord, our opposite party, they came to this honorable court for the second time. That, my lord, page 39.
For the
Again,
second
challenging
time,
our.
no, second, the first one was who?
First one was, my lord,
It was not you who had filed the writ petition.
yes, our opposite party.
Okay, Wajuddin and others.
Then, my lord, after remand, my lord, page 38, we have been nominated, my lord, page 38.
Then this
Then, my lord, it was challenged by them again in
No.
page 39.
39, who is that?
39.
Who is the
39
petitioner?
Yes, my lord. One Abu Zafar Siddiq and my lord Nazrul Islam.
They are different person.
Different persons, my lord.
Or they are different persons.
And Nazrul Islam, of course, my lord, from second one, my lord, he is now in the third round of litigation, man, he is the private person number 5.
Okay. Now they came to the court
They came,
against your nomination.
and then, my lord, our nomination is again cancelled, my lord,
By which order?
by
No.
the order, my lord, page 39,
No, before that, let's see. What was the order passed?
page 36, my lord. 39. Second writ petition, my lord. And page 39, my lord, and my relevant portion, my lord, will find, my lord, page 50, my lord. That is the relevant portion, my lord. Concluding part. It was again, my lord, remanded. It was again remanded, directing the respondent authority, official respondent authorities to nominate the president and vice president, my lord, in accordance with the, my lord, the notification of the government, my lord. Page, my lord, 50.
Earlier also, it was remanded in the similar fashion.
My lord, similar, two times, my lord.
Two
times,
notification. It should be considered.
my lord.
So the earlier one was not in terms of the notification. What was the finding of the court?
Finding of the court.
Your nomination was not in terms
Yes.
of the notification.
Yes, my lord.
So it was set aside,
That was set
remanded
aside.
again.
Matter was remanded back. Again, my lord, same mistakes have been committed by them. Same mistakes committed by them, my lord. Again, my lord, it came to the court in the same line. And the matter has been disposed of under the same line that you follow the terms and conditions given in the notification.
So now what has happened?
And again, my lord, the third time, same mistake. Again, same mistake, my lord. That is why, my lord, at this stage, my lord, I am praying for issuing some rules. Let the other party come, my lord.
Sure. Mistake again and again. What is this?
Only thing is that, my lord, how a committee is to be formed, my lord. The rule says, my lord, rule says that, my lord, the inspector of schools, in consultation with the headmaster and the local people, by holding a meeting, my lord, they will select 2 persons. 2 persons for president and 2 persons for vice president, my lord. And accordingly, these 2 lists, my lord, that has to be forwarded to the deputy commissioner by the inspector of schools, my lord. And the deputy commissioner, my lord, select 1 person, my lord, with the approval of the guardian minister, and, my lord, subsequently approval has been given and committee has been formed. That was the procedure. And here is a case, my lord, no meeting, no consultation, nothing of the sort. Just 1 person has been picked up, and, my lord, nomination has been given, and he has been made president, my lord. And that order, my lord, will find page 53, my lord. That was the impugn order. Here again, my lord, the same mistake. My lord.
Story is never ending. I don't know what is happening. You decide by this notification,
My
two
lord.
notifications. It went back, they decide.
My lord,
Again, party comes back, say that it is not as per the notification.
My
Court again says that you decide according to the notification.
it is my lord. Maybe because of the fact, my lord, the inspector of skills, now he is holding the in charge. And he is taking the benefit, my lord. Either this way or that way, my lord, he is getting the benefit and doing the mistake, knowing.
Who is appearing for the secondary?
I'm yes.
Will issue notice?
Yes, your lordship, but here, this is the competent authority, your lordship. This is the competent.
Okay. So this is a party also, I think.
Yes, your lordship, the main party as respondent first.
Okay. Heard Mr. M.K. Chaudhary, learned counsel for the petitioners, who submits that being aggrieved with the order dated 13/2/2025, appointing the private respondents as the president and vice president of School Management and Development Committee, Rampur, Chalapathar, Sahid Ali High School. White order dated 13/2/2025, bracket annexure G. The petitioners are before this court. The learned counsel submits that in appointing the private respondents, the notification dated 27/6/2016, as well as 27/10/2021. Has not been adhered to. As was directed by this court in WPC number 6054 of 2023. Filed by one Abu Zafar Siddiq and the present respondent number 2. We'll stop. Next para in view of above, issue notice of motion returnable by 4 weeks. Ms. P. Das, learned standing counsel, secondary education department, accepts notice on behalf of respondent numbers
1, 2, and 3.
1, 2, and 3. And Ms. S. Kaur, learned government advocate, accepts notice on behalf of respondent number 4. Stop petitioners to take steps for service of notice upon the respondent numbers 5 and 6 by registered post with ADD within 3 working days. To stop, the petitioners shall also furnish requisite copies of the writ petition to the learned counsels appearing for the respondents today, within 2 days. List again after 4 weeks on a date to be fixed by the registrar.
Highly obliged.
Chiefly opposed.
May I have the lordship? Also, the case of the petitioner is that he is a retired employee. During the service period, he has been suspended. But, and he opposed this high court. During the pendency of that lead petition, he retired lordship. The honorable high court set aside the suspension order, directing the authority to regularize his service, but they have not done it. So the petitioner received low amount of salaries and other pensionable benefit. That is my case, lordship.
Your suspension period has not been regularized.
Regularized,
For that, you are getting lower pension.
lower pension. That is my.
What is that period?
The period is lordship for
Is this a bench 2 matter or bench 3?
bench
Bench 2.
2012, 22, 2012 to 28, 2014.
Okay, the one which you have indicated in your prayer portion.
No,
Prayer portion is different. What is?
lordship, he has been suspended for 2 times, lordship.
Prayer lordship will find it page number 10, madam.
10, lordship.
Yes.
14/9/2007 to 16/9/2008,
8 and
another period is 22/3/2012 to 28/2/2014.
That I've seen. This is a period for which you are claiming subsistence allowance.
lordship.
And what about the regularization of your suspension period?
They have no regularized, lordship. I have annexed the service book also.
No, where is your prayer?
Prayer is not there.
and other post-retirement benefit, unpaid area salary.
Lordship, the exponent released to unpaid supply announced for the period of so and so and so and so, other post-retirement benefit and unpaid area salaries and area amount, area pension.
But this
Amount-
is, this is vague.
That's
Unpaid area salary, or what? Which year, which part? At least tell us that,
from
that period.
2007, 2008, Lordship. That is, I mistake it, Lordship.
You hurriedly drafted your writ petition. We should be meticulous.
So I may be allowed to correct it, Lordship. I amend this petition.
You withdraw and refile. Better. Instead of repairing it here and there, major repair, minor repair,
Lordship.
withdraw and file a fresh one, a good one.
And liberty and example.
Yes, as paid for by the learned counsel for the petitioner, Mr.
And they go.
N.J. Gogoi, writ petition stands disposed of as withdrawn with liberty to file a fresh writ petition, you so advise.
Okay.
The IPF response number 3.5. Mr. S. Vora, learned counsel appears for respondent numbers. BTC. And respondent BTC. Respondent numbers 3, 4, and 5, bracket BTC. And Miss N. Fukan, learned Standing Council Elementary Education Department appears for respondent number 1.
May I please, Your Lord?
Yes,
Matter relates to the appointment of competition ground. Petitioner case was forwarded by the DLC on 10/9/24 to the SLC, my lord. But till now, there no final decision has been taken by the SLC, my lord. That's why I am before your lordship. My name is in page 23, my lord, forwarded by the district level committee. That is serial number 3. Page 23, kindly. Serial number 3, my lord. This
Early-
page is-
just a minute. Earlier you had come before this court.
Yes.
Okay, let us see the first order. Order dated 4/1/23. Have you annexed it?
Yes, my lord.
Come to page 16,
Page 16, yes.
operative portion.
Operative portion, my lord. Page 17, the respondent authorities are in the DLC completion appointment Shonipur as per the relevant office memorandum such and such. Decision in the court of the Achyut Ranjan Das and reported as such and such. Consider the case of petitioner for the appointment completion ground under the guy in harness scheme in gate number 4 post and shall take a decision in terms of the state observation and shall communicate the petition about the outcome of the same. Petitioner shall submit the certified copy of the order to the district level committee. Elementary Education Officer should respond number 5, along with the obtained necessary acknowledgement from the state authority. In that regard, who is in turn shall place the case to be petitioner before the next meeting of the DLC. So accordingly, it was placed before the DLC matter. And DLC has recommended my name to the SLC.
Where is that recommendation? DLC
yes.
minutes.
Page 21, you will find. That was the SLC meeting, DLC meeting. my lord.
DLC meeting.
Yes. In that, my name has will shown in serial number 3, page 23.
DLC Sonitpur.
Yes. Serial number 3, page 23. Biswajit Nath.
Biswajit Nath.
Yes. So accordingly, it was sent by the district level committee to the SLC. my lord. Thereafter, my lord, page is hanging.
Was it forwarded?
It was forwarded, my lord.
When was it forwarded?
My lord, it is not known to us, but DLC has done it, my lord. Naturally, they are after 10, 11.
Even of course, it was a for appointment.
24, 11/9/24.
11/9/24 is
Is the order passed by the DLC?
correct. Now, below that, you see copy for information and necessary action.
Hmm.
Secretary, School Education.
Yes. Dr. Basam, Department of School Education, this person, Superintendent of Police, it is not required. Secretary to the Dr. Basam, Department of School Education, Assam, this would go.
So Secretary will place it before the SLC,
Yes.
isn't it? Yes, Ms. Kaur, what do you say?
It will be done by Education Department, Lordship.
Shall we dispose it of then?
SLC.
My pen can be in that second. So we'll have to take the case down. Let's go to.
No, we can say that they consider, let the SLC consider,
Yes.
Yes.
if not already done in the meantime.
Yes. Lordship can dispose it, madam.
There is one office memorandum,
Yes, sir.
which is, what is the date?
It is not, have not annexed manual here, but it is there. As per the office memorandum, they are doing it, madam. 2015 memorandum is there.
1625.
It's not 2015, something else.
18 September 2024.
18 September 2024.
Meanwhile.
Mr. Biswas, you are aware about that OM?
That I know, madam. That is the, how.
And then why didn't you annex it?
If you require, I will give, madam. If you
Because that OM says,
yes.
OM says no more compassionate appointment because of the introduction of the compassionate
Compassionate pension.
pension scheme.
But my
That is
case is earlier to that. My case is earlier to that. Compassionate pension came in 2017. That thereafter, madam, even thereafter also, our Honorable High Court Coordinating Branch has passed hundreds of orders similarly, forwarding the case to the state company.
No, thing is that the DLC recommendation was before the OM. Then the OM came.
Yes.
So probably that is the reason why the SLC is not sitting.
Then I must be informed, madam, what happened, the weight of my application, which was forwarded by the DLC.
That is why you should have also annexed that OM also, so that we also know what is what.
Well, last OM 2017, I know. If you're one, I lordship, I can, by an affidavit, I can file it. But question is that my case is prior to that. And DLC has recommended. Had there been any embargo, DLC could have stopped it.
There's one common judgment.
There are
Yeah,
so
but-
many judgments by the
Mr.
coordinating
Biswas,
Yes.
please try to understand. We're trying to help you. You should have helped yourself. There's one judgment of this court wherein similarly situated persons, a lot of them
Yes.
had come and one common order was passed.
common order passed.
That all pending cases should be considered. That would have come to your assistance. You should have annexed that
Should I-
copy.
I will bring it.
Your friends might be having that copy. Do you have it? In the next case. Let's see. So we'll dispose it of in line with that, Ms. Quad.
But I'm having it.
No, this is the OM, but the order of the court,
This one is the 24 one.
common judgment, or this is the one. 3/4/25.
Yes, okay.
This right? Heard Mr. S. Biswas, learned counsel for the petitioner, and Ms. S. Kaur, learned government advocate, appearing for the respondent, numbers 2 and 4, and Mr. P.K. Bora, Learned Standing Council, Elementary Education, appearing for respondent numbers 1, 3, and 5. Anybody else left? Full stop. Having regard to the nature of the grievance projected by the petitioner, the writ petition is taken up for disposal at the motion stage itself. Stop next para. It is the case of the petitioner that his father, who was working as headmaster of Gotaimari LP School under Naduar Education Block, Jamuk Gorihat, in the district of Sonitpur, Assam, died in harness on 8/1/2013. We get it from the synopsis. Stop. The petitioner therefore submitted his application for compassionate appointment. But the DLC Sonitpur, which met on the DLC Sonitpur could not recommend his name for appointment on compassionate basis due to non-availability of post. The petitioner subsequently approached this court by filing WPC number 7126 of 2022, which was disposed of by order dated 4/1/2023, by directing the respondent authority concerned to place the case of the petitioner before the next DLC meeting for consideration. Full stop. In terms of the said direction, the petitioner was considered by the DLC Sonitpur, which met on 10/9/2024, and he was recommended along with 5 others for appointment to grade 3/4 post. Full stop. It was also indicated that there was no vacancy in Sonitpur district under the office of the District Elementary Education Officer, Sonitpur. To stop, despite such recommendation, since the case of the petitioner has not been placed before the state level committee bracket SLC, the petition is before this court. Next para. Although the petitioner has not incorporated the office memorandum dated 18/9/2024 issued by the government of Assam in the personnel within bracket capital B department, which is to the effect that in view of the introduction of the compassionate family pension scheme, the compassionate appointment would henceforth be stopped. comma, it may however be noted that this court in a number of writ petitions wherein the petitioners had similar grievance as the present writ petitioner had taken up the matters for consideration and disposed of the cases by a common order dated 3/4/2025. Wherein the lead case was WPC number 342 of 2025. Directing the respondent authorities concerned to consider the case of the petitioners for compassionate appointment in respect of all those pending cases in terms of the relevant guidelines of the state government. Stop. The case of the present writ petitioner only appears to be covered by the state decision. Stop. Accordingly, the respondent authorities are directed to place the case of the petitioner before the next SLC meeting for considering his appointment on compassionate basis. Stop. To facilitate such consideration, the respondent number 1, that is the secretary to the government of Assam, this should be education, isn't it?
Yes.
School education department shall do the needful. Full stop. It is also seen that a copy of the GLC minutes, GLC Sonitpur minutes dated 10/9/2024 was also marked to the said authority at serial number 1. Full stop. With the above observation and direction, writ petition stands disposed of.
Diploma.
Yes, Mr. Sharma.
Yes, my lord. My lord, initially in the year 2023, my lord, your lordship will find those at annexure A and B. There were 2 advertisements, my lord, which were issued. Advertising posts for the post of graduate teachers in arts, science, Hindi and Sanskrit, my lord, in provincialized secondary schools and in government secondary schools. Annexure A and B, my lord. That is not what we are bothered with, my lord. Thereafter, your lordship may kindly come to annexure C at page 37. Page 37, my lord.
Yes.
Yes. My lord, Schedule 3 of the 2018 Secondary Service Rules 2018 were amended. The amendment, my lord, is at page 37. There's a proviso which has been added, my lord, in Schedule 3.
Yes.
Provided that a graduate teacher within bracket mathematics shall have a graduation degree in science with honors or major in mathematics and having physics, chemistry or biology as pass course or minor subjects in the graduate level courses. That is the first part of it, my lord, that in graduate level, an individual who is applying for a post of graduate teacher in mathematics will need to have an honors in mathematics with minor or past subjects either being physics, chemistry, or biology. That is the first part of the proviso.
Hmm.
Then the second part of the proviso starts, my lord. Or post-graduation degree in mathematics from a recognized university with honors or major in mathematics having physics, chemistry, or biology as past course or minor subject with at least 50% marks in either graduation or post-graduation. Now, this proviso, my lord, as my humble submission, is not happily worded because in post-graduation, we do not have a concept of honors. In post-graduation, it's a master degree course, my lord. It's just one subject. Now, what this means, the second part of the proviso means that notwithstanding an incumbent or a candidate having a post-graduation in mathematics, it also has to be fortified by graduation in mathematics along with either physics, chemistry, or biology. So the graduation in mathematics with honors and physics, chemistry, or biology is a prerequisite. Thereafter, an individual may or may not have a post-graduation in mathematics. That is what the proviso means. So there are two stages, my lord, for an incumbent to be eligible for the post of graduate teachers. Because your lordship would see post-graduation degree in mathematics from a recognized university with honors or major in mathematics. That is not possible because we have the concept of honors or majors in the graduation level.
See,
yes,
there are two things.
There are two.
One is the first one is that
Yes.
graduation degree
Yes.
in science
Yes.
with honors or major in mathematics.
Yes.
Then having physics, chemistry, biology, chemistry or biology.
Yes, physics, chemistry, or biology.
So it can be either chemistry or biology.
No, it's physics, chemistry, or biology. Either one of these.
Okay, one of them.
Yes, yes, my lord. Yes, my lord.
Having physics, chemistry or biology as past course,
Yes.
minor subject.
Yes.
So you should have a subject on physics, chemistry, or biology.
Either those.
And have a major subject in mathematics.
Yes, yes. That is the first part of the proviso. Yes.
That's the first.
Yes.
Second one is PG degree.
Yes.
In mathematics.
Yes. So
Then-
the post-graduation, we say it's master degree. The master degree has to be in mathematics.
And your honors has to be in mathematics.
Yes. Now the honors, there is no concept of honors in MSc. So your lordship would see.
No. The PG is different. It's that honor is not attached to PG.
It's not, yes.
PG is there.
PG is there.
Separately, honors or major in mathematics, having physics, chemistry, biology.
Yes. So if an incumbent, so today, my lord, if I'm applying for the post of a graduate teacher in mathematics, what the authorities would need to do is that they would need to check whether I have a post-graduation in mathematics. If I fulfill that criteria, then the authorities will look into the fact that whether I had mathematics as honors in graduation with a combination of physics, chemistry, or biology.
It comes to the same thing, I believe.
No, the graduation level, my lord, if the post-graduation, if I have a post-graduation in mathematics, because post-graduation is done in only one subject. If I have a post-graduation in mathematics, that alone does not entitle me to be considered. Because what happens, my lord, even in humanities, my lord, there is a possibility of me studying mathematics. Now, assuming I have had humanities in graduation level, and then I do a master degree course in mathematics for post-graduation, that will not entitle me for the post of graduate teacher. What this rule indicates, my lord, that I would have had to have mathematics.
This is regarding graduate teacher in science.
In mathematics.
In mathematics.
In mathematics. So the graduation degree in mathematics along with the post-graduation degree, that is what the proviso to the rule says.
So what the requirement is that you should have the honors.
Yes.
Postgraduate or graduation. Yes. With mathematics as major.
Yes.
But at least you should have one of the science subjects.
Yes.
Physics, chemistry, or biology.
Exactly. And if I'm having a post-graduation in mathematics, that alone doesn't entitle me to be considered. The authorities will also need my graduation.
You still need to have that graduation.
Yes.
With that science subject.
Yes, my lord. Absolutely, my lord. That is my submission, my lord.
So that is why it appears that 1 and 2 is more or less the same thing.
1 and 2 are more or less the same. The 2 is
1 says graduation, 2 says post-graduation.
Yes.
Post-graduation is something additional.
Yes, exactly.
Because post-graduation also alone is not acceptable.
Not acceptable.
It comes with honors in mathematics.
Absolutely, my lord.
With science background.
Yeah, absolutely, my lord. That is what my submission is. That is where the entire matter rests. Now, there was slight confusion regarding interpretation of the rules. Your lordship would kindly come to page 44. Page 44, my lord.
Speaking order.
It's a speaking order, my lord, which was issued last month, 4th of July, 2025. My lord, if I may be permitted to read, my lord, the third paragraph onwards.
Yes.
The provision stipulated in the amended Schedule 3 of the Assam Secondary Education Provincialized Schools Service Third Amendment Rules 2024, the following proviso is inserted and read as, quote unquote, provided that the graduate teacher mathematics shall have a graduation degree in science with honors or major in mathematics and with physics, chemistry, or biology as a pass course or minor subject at the graduate level, or a postgraduate degree in mathematics from a recognized university with honors or major in mathematics and with physics, chemistry, or biology as a pass course or minor subject with at least 50% marks in either graduation or post-graduation. My lord, we have just gone through that provision, my lord. That is just a repetition of that, the amendment. Then, my lord, the department had duly examined the said proviso in the rules, and it is hereby clarified that the rule clearly means that a candidate must have studied any one among physics, chemistry, or biology as a pass course or minor subject, along with mathematics as major or honors. This clarification is issued with compliance by the Director of Secondary Education and the concerned inspector so-and-so. So the prerequisite to be considered for a graduate teacher in mathematics, notwithstanding I have a post-graduation degree on mathematics or not, would be that I need to compulsorily have honors in mathematics, followed by any combination of these three subjects. Now, my lord, the issue which is arisen for this honorable court, my lord, that we are only praying for the secondary education to comply with the direction of the rules, the mandate of the rules. My lord, my submission is, your lordship may kindly come to page 85. These are the sample application forms, my lord, page 85. The applicant, my lord, his name features it as Asadul Haq, my lord. He is one of the petitioners in this case. Now, my lord will come to kindly page 86. Page 86.
This is an online application form.
Yes, my lord. This is a picture that was the screenshot which was taken, my lord. Page 86 will be relevant. Your lordship would see the second row, first column, my lord. Do you have honor or major in mathematics and having physics, chemistry, or biology as pass course or minor course in the graduate level courses? The answer is yes or no. Then the second question is, do you have a post-graduation degree in mathematics from a recognized university with honor or major in mathematics? The same thing. The answer is either yes or a no. Now, in this matter, my lord, the candidate has clicked on yes in the first question, which entitles him to answer the following questions. Now, this submission, my lord, is substantiated. If your lordship can kindly come to page 87. This is a screenshot, my lord. This is a screenshot, page 87, annexure L. Your lordship sees that question. Do you have honor or major in mathematics and having physics, chemistry, or biology as a pass course or minor subject in the graduate level courses? If I click on no, the answer that comes, my lord, is that you are not eligible for graduate teacher mathematics. Your lordship sees that.
What is the question? Do you have any?
The question is, do you have honor or major in mathematics and having physics, chemistry, or biology as pass course or minor subject in the graduate level courses? This question, my lord, corresponds to the question on the previous page, at page 86.
Correct. So
yes. Now
this is as per the rules only.
This is absolutely as per the rules. Now, the moment I click on no in the first question, notwithstanding the fact that I might have a post-graduation mathematics at the post-graduation level, that still doesn't entitle me for the post of graduate teacher mathematics.
Okay, the second part.
Yes. The second question. But irrespective of the second question being a yes, if it's a no, yes.
Before you have been asked whether you have a post-graduation.
Yes. So that
you're disqualified.
Yes, yes. No, I'm qualified. But this is just as a sample to indicate before the court that if I do not have a graduation degree in mathematics, it doesn't entitle me to be considered for the post of graduate teacher in mathematics. That is what the drop-down list also says.
Who gets admission in post-graduation unless you have post-graduation? Graduation.
I may have mathematics as a part of a different combination, or in humanities, or in BCom. So my graduation could have been done in science. My graduation could have been done in commerce. My graduation could be done in humanities with mathematics as one of the subjects. And in post-graduation, I could have still taken
Is
mathematics.
it your case that you cannot be restricted to, one cannot be restricted to the background having science, having biology,
No.
chemistry or physics?
My case is to be restricted.
To
My
be
case is
restricted.
that I wish to be restricted by the rules. That is my submission.
Hmm.
Now, the issue what has happened here, my lord, is that if your lordship sees the fields which are there to be filled up, it is not substantiated by any document uploading portal. So a simple yes or a no would entitle an individual to pass that threshold. Now,
That will be the preliminary screening.
now what has happened?
Ultimately, I think this
No. Yes.
subsequent verification will follow.
No, now what has happened, my lord, will kindly come to page, paragraph number 23. Paragraph 23. That is our only concern. Paragraph 23, my lord.
Paragraph 23 of what?
23.
Page.
At page 15, my lord. Page 15. Paragraph 23 at page 15. This is for our information, my lord. I've appended, my lord, as a sample for your court's perusal, my lord, 3 candidates' candidature. Ms. Sahanas Yasmin, 1 Mr. Abu Hanif Sarkar, and 1 Mr. Saminul Haq. They have entered the fray. Their name features, my lord, their name features in the second list. Now, what has happened?
Second list.
Second
means-
list. There are 2 lists which have been published as of now. 2 lists
What-
of
what
eligible
list?
candidates. My lord,
Eligible candidates.
Eligible candidates.
After filling out the online
After filling
application.
the form, and then there was an examination which was also held on 19 January 2025.
Hmm.
Thereafter, selected candidates were called for document verification.
Hmm.
In that document verification, individuals who do not have a graduation in mathematics as honors or physics, chemistry, or biology as one of the past courses have entered the fray.
Hmm. You have taken 3 names.
I've taken 3 names as a sample, my lord. The select list has not yet been published. It's in the stage of document verification.
What is their background?
My lord,
What is their background?
the background, my lord,
These 3 individuals.
my lord, these individuals, they don't have a graduation degree in mathematics. That is something that we could not substantiate by records, and hence we made a submission by knowledge, my lord. The fact of the matter is, my lord, there is a representation which has also been preferred by the petitioners at page 122, raising this issue before the authorities. Now, the authorities, my lord, in right or wrong, they've taken a view that either mathematics as honors in graduation or post-graduation in mathematics, either of these 2 requirements will suffice. So a lot of individuals who haven't had their major done in mathematics at the graduate level has entered the fray. Our prayer by this petition, my lord, is to only restrict the advertisement process as per the amendment of the rules and as per the terms of the advertisement. We are not challenging any portion or provision of the advertisement or the rules. We want to be confined to the graduation in mathematics and post-graduation in mathematics, what all the petitioners have. Your lordship, we have prepared a small table for your lordship's convenience at page 17. Page 17, my lord. Paragraph 27. Paragraph 27, page 17. This is the combination which is either eligible or ineligible. Serial number is that we have a graduation degree in science with major in mathematics and having physics, chemistry, or biology. I have no post-graduation. I'm still eligible. I have a graduate degree in science with honors or major in mathematics with either physics, chemistry, or biology as a past course, and a post-graduation in mathematics. I'm eligible. Then I have a post-graduation and graduation in mathematics. I'm eligible. The ineligibility part, my lord, starts from serial number 5 on the next page. So the authorities, my lord,
No, from serial number 5, they are not eligible.
they're not eligible. Because in the first column, graduation degree in science with honor or major other than mathematics. So both the provisos have to be strictly.
5, 6, and 7
5, 6, and 7 are
not eligible.
Not eligible.
So candidates having this 5, 6, and 7
Yes,
are
my lord,
being,
they have entered the fray.
they've entered the
Yes,
fray.
third party rights have not accrued, my lord.
So,
because-
but how do you say that?
My lord, these are my submissions on oath, my lord, at paragraph number 23.
How do you know?
My lord, this is as per knowledge, because the fact is, when those documentation of the candidates are in the private domain, my lord, it is as per the common knowledge, I'm willing to be, my lord, stand by the submission. It is my submission on oath before this court, my
And
lord.
who's the petitioner before this
The
court?
petitioner, there are 12 petitioners, my lord.
They are the participants of that
Selection process. Yes, my lord.
Okay.
The selection process has not attained finality. It is in the document verification stage.
So immediately the question will be, what is your locus?
Because you participated, my lord.
You participated.
Our admit cards are at page 45 onwards.
No, it is yet to be decided whether these persons are to be considered to
My
be
lord, the moment
eligible or not.
absolutely, my lord. The moment, my lord, moment the selection completion, the selection process is completed. Third party rights, my lord, amounting to probably 1737 posts would arise. We have challenged it. It's not premature, my lord. Our submission is based on the fact that page 83 and 84.
83, 84.
83 and 84, my lord. These are what the cause of action has arisen from, my lord. Page 83 and page 84.
What are these?
These are the cutoff marks. These are the cutoff marks for the paper 1 and paper 2, which have been published. And my lord will kindly come to, my lord, page 88. Page 88. Page 88 are the list of candidates, my lord, who have been called for document verification. Page
Yes.
88.
Yes.
Those 3 names which have been taken, my lord, have been taken from this list.
Where are they?
My lord, if your lordship kindly comes to page 90, my lord. Page 90. I apologize, my lord. There is a small pencil mark which actually indicates it ought not to have happened. Page 90, my lord. Your lordship sees Sahanas Yasmin.
Pencil mark.
Pencil mark, my lord. I apologize, my lord. That should not have been there, my lord.
No, you have already used X,
Oh, I've used, oh, it is in my copy.
but it's still legible.
It's, yes, my lord. That should not have happened, my lord.
Yasmin.
Yes, man. Shahana
Then-
Yasmin.
Who else?
Then my lord will come to page 113. Page 113. My lord, 1, 2, 3, 4. The 6th name from the bottom, my lord, Saminul Haq. Then your lordship will kindly come to page 116. 1, 2, 3, 4, 5, 6, 7. The 8th name from the bottom, my lord, Abu Hanif Sarkar. Now, these are just exhaustive examples, my lord. If the authority, if the government consents to the fact that the rules will be abided by, then we have no case. The lordship will allow the petition. The only issue which is arisen here is that the authorities, subject to my senior friend's submission, my lord, they have not been correctly able to ascertain the qualifications which are needed. My prayer is that we need to abide by the rules. That is my submission, my lord. I have nothing else to submit for this court. That only candidates.
No,
Yes,
first
ma'am.
of all, you tell me, how do you know that these people are not having that particular
This
qualification?
is as per my knowledge, my lord. It's in the affidavit, my lord. This statement is as per my knowledge. And in fact, my lord, we have submitted a representation to that effect.
How do you proceed with such kind of allegation?
My lord, page 122. Otherwise,
Without-
my lord, we would have not approached this honorable court for compliance with the rules. We have approached this honorable court for compliance with the rules only because we understand, my lord, that there have been certain deviations.
Where's your statement to that effect? Page 20.
23 is where, my lord, I've taken the names. No, page 15. No, I'm sorry. Page 15 is where my statement, paragraph 23.
You have just taken names, that's all.
That's all, my lord. My lord, in fact, we
So
have
how-
taken.
So how, where is the allegation that these people has only this
There'll be,
particular
there'll be no
qualification?
allegations, my lord. The fact is,
Huh?
my lord, the allegation has to come from somebody who's affected. We are the affected party. We have,
No, how are you affected as of today?
as of today, my lord, what has happened?
And
to
how
us-
do you know these
Yes,
people don't
yes,
have
my-
that qualification?
My lord, the reason why this issue has come up is, your lordship will kindly come to page 83 and 84. 83 and 84. Page 83, my lord.
Hmm.
Your lordship sees that.
Yes, these are marks.
These are cutoff marks.
Hmm.
The first list, my lord, at serial number 4 is graduate teacher mathematics. The last row, my lord.
Yes.
There, your lordship will see the first row is Assamese,
Hmm.
unreserved 57.
Hmm.
That's the cutoff mark.
Hmm.
My lord, we are all competing for the post of Assamese graduate teachers in mathematics in the unreserved category. The cutoff mark is 57. Then your lordship will see the second cutoff list. The list 2 has come out, where the cutoff percentage has dipped to 50. We do not fulfill that 50% cutoff mark as of yet, my lord. Our marks are lesser than that. Now, our claim is that because individuals with the different subject combinations have entered the fray, the cutoff marks have increased to a level which we have not been able to compete.
Hmm.
Because the examinations which are held are not strictly based on mathematics, but it's an APSC regulated format. So the cutoff marks have been spiked. Now, if individuals who are not eligible are taken off, it is my humble submission, my lord, that there's a possibility that the cutoff marks will dip. I'm not seeking an appointment. I'm not seeking appointment, my lord. I'm only seeking parity of my selection being as per the rules. That is my submission, my lord. We are not claiming any other relief from this court.
Come to your prayer portion. What
Yes.
have you sought for? Let's see.
Yes. My lord, my first prayer, if I may be permitted to read, my lord.
Yes.
A writ in the nature of mandamus should not be issued, directing the respondent authorities to select and appoint candidates pursuant to the terms of the advertisement dated 16/10/2024, calling for applications for the post of graduate teacher in various provincialized secondary schools and government secondary schools in the state of Assam, read in accordance with the Assam Secondary Education Provincialized Schools Rules 2018, as well as in accordance with the speaking order dated 4/7/2025. That is as per the law. And the second prayer, my lord, is that a writ in the nature of mandamus should not be issued, directing the respondent authorities to cause an inquiry and thereafter reject candidature of such candidates who do not possess the basic eligibility criteria of a graduation degree in science with honor or major in mathematics and having physics, chemistry, or biology as a pass course or minor subject in the graduate level courses with at least 50% marks in graduation, or B, a post-graduation degree in mathematics with at least 50% marks in post-graduation with a graduation degree in science with honor or major in mathematics and having physics, chemistry, or biology as a pass course.
Hmm. Your writ petition is based on apprehension.
No, my lord, these are apprehensions, but the fact of the matter remains, my lord, that the entire petition, the documents belong to individuals' private domain, my lord. We have sought those documents and those documents are not with us. We are making a submission on oath before this court, my lord. If my submissions are not found to be correct, my lord, your lordship will issue appropriate directions, my lord. My submissions is bona fide. In fact, my lord, we've preferred a representation. If rules were the only criteria holding us back, my lord, we would not have come before this honorable court. We are saying that we abide by the rules. That is my submission. My lord, 122 is a detailed representation. In fact, we have been given verbal assurances that the rules will be adhered to. In fact, all of those candidates, they have not been rejected. The candidatures have not been rejected. Now what has happened is that because outsiders have come into the fray with different subject combinations, the cutoff marks have been spiked up. There is a possibility of-
Okay, I've
Yes.
understood your case.
Yes, my lord. That is my prayer, my lord.
You want to submit something?
Only one thing that nothing has crystallized till now.
Absolutely.
His own submission and
Yes.
Lordship has also said the same thing, that we are at the stage of verification. The verification is going on. And there are one or two stages where in the portal they have to say that I am postgraduate or I am not postgraduate or subject. yes, no, those buttons are clicked. So that is the initial stage on the basis of which we prepared a list. And at the final stage, when the practically the documents are verified, the actual things comes out. So somebody may pass through the first phase or second phase, but in the ultimate verification, their whole thing will come out. So till now, nothing has crystallized. So it is purely on apprehension this case has been filed. In that view of the matter, Lordship, that this petition is not maintainable at this stage. They themselves has said in paragraph 24, 23 in the page 16, the petitioner now validly apprehends. So there is a apprehension. So on apprehension, this honorable court will not examine. Their whole case may fall flat at the end. So they should not actually consume this honorable court's precious time at this stage. So either they let them withdraw and an appropriate they can come if we have done anything wrong. But till now, whether we have committed right or wrong, that has not also not done. That situation is not over. So purely on apprehension, this kind of repetition may not be entertained at all in my humble submission.
Okay. So I'll come back in 5 minutes and pass the orders.
My colleague will be here now.
Surely.
Be clear.
Pardon, Mr.
I have just one more submission, small submission, but I'll not take more than 2 minutes, ma'am.
I think you have made enough submission. I'm disposing it of.
Yes, madam. Yes, madam.
Part Mr. M. Sharma, learned counsel for the petitioners.
Yes.
Who submits that the petitioners are aspirants for the post of graduate teacher
Mathematics.
in mathematics. What is this Assamese thing?
Medium.
In the Assamese medium.
Yes, medium.
Which Assamese medium? School.
Assamese medium.
Secondary schools.
Secondary schools.
Assamese medium.
Government secondary schools.
Assamese medium, provincialized and government secondary schools. The Learned Counsel submits that as per the relevant rules, no, as per the Assam secondary education, open bracket, provincialized schools, close bracket, service rules, 2018. As amended in the year 2024. Schedule Roman 3 in clause within bracket small Roman 2. No, Schedule Roman 3 provides that where's the main rules?
I don't. It's yeah. My lord. Page 54, my lord, is the schedule.
It's okay. It's okay. Provides that in order to be qualified to be a graduate teacher in mathematics, one shall have to have graduation degree in science with honors or major in mathematics and having physics, chemistry or biology as pass course in minor subjects in graduate level courses. Stop. If not, one should have post-graduation degree in mathematics from a recognized university with honors or major in mathematics, having physics, chemistry or biology as pass course or minor subjects with at least 50% marks in either graduation or post-graduation. Stop. In order to clarify any confusion into the matter, a speaking order dated 4/7/2025 was also issued by the Secretary to the Government of Assam, Department of School Education. Stop. The Learned Counsel submits that despite the same, the petitioners have come to learn that there are applicants who do not have the requisite qualification as stipulated in the rules, but whose names have found place, who have found place in the list of eligible candidates for document verification. Stop. The Learned Counsel submits that such candidates who have found their names in the list,
Second select list, my lord.
in the second select list for document verification, though
They have PG in mathematics, but not graduation.
though having postgraduate degree in mathematics, but they do not have graduation degree in mathematics with the combination of physics, chemistry, or biology as past course or minor subjects. And because of which the cutoff marks have gone up from 57 marks in respect of graduate teacher mathematics in Assamese medium, unreserved category,
Yes.
in the first list to 50 marks in the second list.
Yes, ma'am.
Stop. Such being the position, the petitioners will lose their chance of being considered despite possessing the requisite qualification in view of the high cutoff marks created by inclusion of ineligible candidates. Next para, on a pointed query made by this court as to who are such candidates not having the in mathematics and with supporting materials to that effect from the Learned Counsel for the petitioners fairly admits that he does not have the details as such, but knowledge has been gathered to that effect that there are many persons not having degree in mathematics. The Mr. D. Saikia, Learned Advocate General Assam, assisted by Mr. SMT Chisti, Learned Standing Council, Higher Education, Secondary Education, submits that the entire selection process is only at the verification stage, and that if the candidates and whether the candidates call for document verification possess the requisite qualification or not will be looked into at the time of such document verification. Stop. He therefore submits that the writ petition is only premature. Next, para, upon considering the submissions made and upon perusal of the materials available on record.
And also they have on apprehension date, filed this petition. That was also.
This court finds that the writ petition has been initiated on the basis of apprehension made by the petitioners. On the basis of apprehension of the petitioners, that those who are not qualified would be considered for appointment to the posts in question. Stop, without there being any such materials to substantiate such apprehension. This court is not inclined to entertain this writ petition, and the writ petition therefore stands dismissed in limine. Next para. Notwithstanding the dismissal of the writ petition, it is also observed that the selection process observe that you can, it goes without saying that the selection process would have to strictly abide by the relevant provisions of the Assam Secondary Education bracket Provincialized Schools close bracket Service Rules 2018 as amended,
And the terms of the advertisement also.
the terms of the advertisement, and also the speaking order issued on 4 July 2025.
If my lord, I'm grateful, my lord, this order should suffice as of now, my lord. If your lordship can kindly observe that graduation degree in mathematics is a prerequisite, because the authority's understanding of the provisions has created.
No. I don't. I am not giving any clarification.
Yes, no.
Rules speaks for itself.
Yes.
They have provided a speaking order. If they don't understand, and if there's some complication, door is always open to you.
The multiple third party rights. I'm grateful, my lord.
Yeah, Lordship, this matter relates to compulsion amendment of the DLC recommended, now there is recommended, Lordship, recommended page 39, Lordship. Sorry, Lordship, please. Page 18, Lordship, 11 portion, Lordship, kindly see page 21, serial number 10. Page 21. Serial number 10, Lordship. Recommended, Lordship. In the right side, the earlier proposals was placed.
Mira Begum. Mira Begum.
Yes, yes, Lordship.
Name.
Yes, Mira Begum, yes, Lordship.
That is a petitioner.
Yes, Lordship.
And DLC is of which date?
Lordship dated DLC 7/3/23, Lordship. And Lordship's order is page 39, Lordship. Page 13 is Lordship's order. WPC 3520. I'm praying for refer them at a assets, Lordship.
What is the remark at page 21?
Lordship, the earlier proposal was placed twice before DLC meeting held on 13/8/14 and 22/6/16. Firstly, the proposal was rejected considering the better financial condition of the then recommended applicant. Moreover, it was felt that the age group of the members of the family was compared to that of the recommended candidates, placed them in an advantageous position to explore other avenue and engagement income. And secondly, rejected the proposal due to balance of period service deceased was less than 3 years. In this meeting, it is decided to forward the proposal to the GOV for further necessary action. Now I am praying to consider the SLC as per rule, Lordship, nothing else.
So they're just forwarded,
Yes, Lordship.
no recommendation.
Yes, Lordship, it is recommended, Lordship. Accepted, Lordship. Can you see the column on the left side? Accepted, assistant teacher LP school.
What is that? What is that? What does it mean accepted?
Lordship, the proposal is accepted. Maybe language is something different, but it's forwarded to the government, Lordship. Now the SLC, Lordship, forwarded to the SLC.
Application may be accepted, Lordship, but
Yes.
this clearly stated that rejected the proposal due to balance of period of service deceased was less than 3 years. That issue is alive, Lordship, and one appeal is pending before this honorable court, Lordship.
That I'm coming, Lordship. That is, this finding is not true, Lordship. Kindly see page 25, Lordship. The service book is there, they are wrongly mentioned, Lordship. Still, I have the service more than 16 years, Lordship. Page 25 is the service book, Lordship. The husband of the petitioner, date of birth is 1968.
Balance period of 3 years thing was found to be unconstitutional by the single judge.
No,
Then
Lordship,
the status before appeal.
Appeal, yes.
There is no outcome.
There is no stay order, Lordship. There is no stay order, Lordship. There is no stay order, Lordship. Whatever may be, Lordship. Now, for that clarification, page 25, Lordship, kindly see the service book. Still, I have more than 16 years of service. That finding is wrong, Lordship.
Where?
Page 25.
Service book.
Yes, Lordship. Page 25.
You have a service book.
My husband has a service book, Lordship. The petitioner's husband died in.
Okay, that 3 years has to be the government servant.
Yes, Lordship.
Okay.
But now, Lordship, I have more than 16 service. This finding is wrong, Lordship. Kindly see, Lordship, page 25. Serial number 5, Lordship. Date of birth is 1968. And a government employee has a service of 60 years, Lordship, he retired. And if 1968 plus 60 is counted, Lordship, he will be retired on 2028, Lordship. But here, Lordship, the date of death is mentioned in third column, date of retirement is page 712. And date of death is mentioned 2012. In Lordship, 1968 plus 60 is counted, Lordship. Thus, he was supposed to be retired 2028. 2028, still he has more than 16 years service, 16 years. But they wrongly mentioned in the recommendation, he has less than 3 years of service. That finding is wrong, Lordship. That is why I have enclosed this part of this service book, Lordship. 68 is date of birth and plus 60. Then 2028, Lordship. And 2028, he will be 60, Lordship. Then retirement is 60, Lordship. Then 16 years of service still is in hand there, Lordship. Lordship.
According to the entry made here, date of retirement will be 54 years.
There is a wrongly mentioned, Lordship.
54 years. What is the retirement age?
60, Lordship.
60.
His date of birth is 1968.
So there's something wrong out here, isn't it?
Yes, sir, Lordship.
If he's born in 68
Yes.
March,
Yes,
then he will be retiring in
2028.
March of 2028.
Yes. Finding also wrong, that's it, Lordship.
Finding wrong, but you are also relying upon that finding.
Now, Lordship, the SLC will verify and they will pass as per law, Lordship.
Now only prior lordship, the OMS for this OM lordship, I have come to before this honorable court. Page 39 is the lord.
Just a
lordship order.
minute, okay, just what is that order?
Similarly situated person lordship.
Oh, similarly situated
Yes,
person,
lordship. Yes.
not the present petition.
No, no. Lordship. It starts from page 40 lordship. Referring this, all this OMN order, lordship has referred them to SLC.
Yes, Ms. Kowar will
Additional lordship, notice may go lordship. Notice may go.
notice.
Yes, lordship.
Only SLC will consider what they will reject lordship.
It is also pending lordship, and on the other hand, lordship, as per the petitioner, there is a controversy between the age, retirement age lordship. That also not challenged by them lordship. Also not corrected by them also lordship. So I think lordship notice may go at this stage.
Why lordship notice is required? Lordship is a case to be disposed of, and SLC will verify. If it is wrong, they will reject lordship. I have nothing. I have come with a small prayer. Only this OM lordship, my case was not placed. This I am praying for lordship. The OM person to this OM lordship, many case has been disposed of, and my case will be, and everything will be scrutinized. And if it is anything is against me, they will reject lordship only to place in SLC lordship. That much only. The notice will everything in record lordship.
I think we can dispose it of, Ms. Kowar. I will record your submission if you want.
Yes, sir.
So even to pending lordship,
Hmm?
there is still lordship.
No, that I understand, but you see the document given here
25. Yes.
at page 25. Husband was, date of birth is 1968.
Yes.
So he has 3 years left.
Why it is required to challenge? I don't know what
May
the
not,
submission.
may not be required to challenge. We clarified that here. And the SLC will have the liberty to scrutinize that also.
I will open instruction lordship.
SLC will have the liberty to scrutinize that.
Yes.
I'll make a mention of that also.
Yes. Yes, sir.
Heard Mr.
S.U. Ahmed.
S.U. Ahmed, learned counsel for the petitioner. Who submits that by filing this writ petition, the petitioner seeks for a direction to the respondent authorities to place the case of the petitioner before the state level committee bracket SLC for considering our case. She's the husband, she's the
Yes,
wife.
Yes, sir.
Our case for compassion appointment. In terms of the recommendation made by the district level committee bracket DLC, Mangalday, no, Darang Mangalday, which held its meeting on 7/7/2023. Stop the learned counsel submits that the husband of the petitioner died in harness on 3/7/2012 while working as an assistant teacher at number 617 Dakshin Bokorajar LP School in the district of Darang, Assam. Stop the learned counsel submits that although the DLC had made an observation that The application of the petitioner initially was rejected on ground of due to lack of balance period of service of 3 years of the deceased. But the petitioner's application was accepted and decided to be forwarded to the government for further necessary action. So the learned counsel submits that as per the service book of the late husband of the petitioner, annexed as annexure 4 to the writ petition, his date of birth is 30/3/1968. The retirement age being 60 years, the late husband of the petitioner, if still alive, would have retired on 2028. The DLC having made its recommendation on 7/7/2023, the petitioner, the deceased person clearly had the balance years of service left. And such being the position, finding to that effect, is not correct. Be that as it may, the learned counsel submits that since it has been proposed to forward the case of the petitioner before the SLC, the SLC may be directed to consider the case of the petitioner. Next para. It is also seen that White Office Memorandum dated 18/9/2024, the Government of Assam in the Personnel within bracket B department had notified that henceforth compassionate appointment would be stopped in view of the introduction of compassionate family pension. However, a number of cases with similar grievance was taken up for consideration by the coordinate bench of this court. And was disposed of on White Order dated 3/4/2025, wherein the lead case was WPC number 342 of 2025. Court directed that all pending cases for compassionate appointment be considered in terms of the relevant guidelines of the state government. Admittedly, the case of the petitioner is squarely covered by the said decision. Next para, in view of above, the respondents are directed to consider the case of the petitioner in the next SLC sitting, and for which the Secretary to the Government of Assam, Department of School Education, bracket respondent number 1, shall do the needful. Next para, Ms. S. Kowar, Learned Government Standing Counsel, Learned Government Advocate, Junior Government Advocate, appears for respondent number 3,
2 and 3.
2 and 3. Should I record your name also? Ms. D.T. Burman and Ms. S. Kowar, learned state councils appear for the respondent numbers 1,
2 and
respondent numbers 2 and 3. And they submit that they may be given some time to obtain instruction in the matter. Stop. However, in view of the materials available on record, court is of the view that the matter can be disposed of at this stage. This you incorporate somewhere in the beginning part, okay? Disposed.
Page 25, net qualifying service is 13 years, 4 months to basic. In page 25, Lordship, net qualifying service is 13 years, Lordship. 13 years in left-hand side, Lordship. I think there is some discrepancy in this document, Lordship.
They will verify, Lordship. I don't know why.
After verification,
Yes.
after due verification.
Yes, definitely. They will verify.
One more line, notwithstanding the forwarding made by the DLC concerned, the SLC will be at liberty to scrutinize and examine the case of the petitioner in accordance with law.
Yes. Lordship, 14 also same, Lordship, DLC recommended. Lordship, the ground of.
In this case, Lordship, I have.
Let me complete. My Lord will decide whether it will record or not. Lordship, kindly see page 24, Lordship. DLC recommendation, and my name appears at serial number 16, Lordship, Bobita Deka. Lordship, got it?
Yes.
The earlier proposal was placed before the DLC meeting held on so-and-so and rejected due to balance service of period the deceased is less than 3 years. So proposal could not be considered. Now it is proposed to forward to the GOV for consideration. Lordship, here also the same thing, Lordship. Lordship, kindly see page 27. The service book, Lordship. Serial number 5, Lordship.
Page
27, Annex 4. 27. Lordship, serial number 5, date of birth 1961. And if Lordship, the 1961 and 60 years is counted, Lordship, then 8 years service is there in his hand, Lordship. But here date of joining 84 and date of retirement, date of death is mentioned and date of retirement is vacant, Lordship. So Lordship, still I have more than 8 years of service.
But then why did they put this remark?
Lordship.
Why did they put this remark? That earlier DLC rejected because lack of balance service.
Yes, Lordship. The earlier proposal was placed before the DLC meeting held and rejected due to balance service of period less than 3 years. The proposal could not be considered. Now it is proposed to forward the GOV for consideration. Lordship, those are not verified the documents. That is why now they have seen that it is genuine, Lordship, then forward, Lordship. Now my only prayer that the SLC will verify and they will either reject or dismiss, Lordship. This much only, Lordship.
Lordship, in this case, Lordship, one of them may be just that. For I
don't
have to take
understand.
instruction, Lordship, why the deputy commissioner has, Lordship, written this, Lordship. The remaining, I have to take instruction, on what basis, Lordship?
Now, Lordship, kindly see the page, Lordship.
If
Page
it's correct, then
page-
Lordship.
Page 20, Lordship. Page 20, Lordship. 20A.
Page 27 is a part of the service book.
Yes, Lordship. That is why, Lordship. Only all these things can be verified by the SLC is there, Lordship. It is not the DLC recommend and SLC will consider, Lordship. On their own, Lordship. SLC is the supreme authority. And my friend being should assist the court only. Now, why instruction is not regard this type of case, Lordship? And the SLC is there, the authority, they will verify. If it is not genuine, they will reject.
No, instructions are required sometimes.
Yes,
See,
Lordship. That's true, Lordship. But
this is not your personal case.
no, Lordship.
You have filed on instructions of your client.
Yes, Lordship.
So similar thing will apply to the other side also.
Yes, Lordship. But this is on record, Lordship.
They have seen your writ petition. Now they said, and without instructions, they cannot give their own thing. Na?
That's true, Lordship. Then if,
Pending
but otherwise, Lordship,
Lordship.
the finding is wrong and on as per record, Lordship, 8 years, more than 8 years service there. The SEL will verify, if not genuine, then they'll reject it. That is why, Lordship, my simple period, nothing else, Lordship.
Ms. Burman,
Yes,
on the other hand, we have allowed one of the writ petition. So this is on similar basis.
but Lord, only
The
one.
liberty is always there to
Yes.
scrutinize and reject.
Yes.
It's up to you. So you're not curtailed from rejecting it. So that remark I've given.
Yes, Lordship.
But the issue is Lordship still pending, Lordship is remaining balance period of 3 years, Lordship, the retail in the division bench has stayed, Lordship. The matter, Lordship.
No, that is there,
Yes,
but
Lordship.
here,
But-
if you see the service book,
Yes,
Yes.
27.
if you see the service book, date of birth is 1961.
I mean, date of birth is not correct, Lordship, written in the.
That is why you can scrutinize. SLC will call the records and scrutinize.
Yes,
If if 61 is wrong, then they
Yes.
will reject immediately.
And I have to retire in 2021, Lordship. If I.
So I think similar order, okay. Only difference here is
Wait.
DLC is
Same DLC, Lordship. Mangalday, Dardarong, Mangalday. Dated 7/7.
date also same.
No, Lordship, DLC dated 7/7/23.
Where's the beginning part?
Lordship, page 20, Lordship.
Okay, DLC,
7/7/22.
where do you get the date?
Lordship, in the second
Okay.
time,
DLC date, DLC,
meeting held on 7/7/22.
DLC Darang Mangaldoy, okay? 7/7/2022. And
The here is the Lordship father of the petitioner.
father of the petitioner.
And died on 19/8/23.
Father of the petitioner, working as upper division assistant. In the establishment of Block Elementary Education Officer, Sipa Jhar, Darang District, died on 19/8/2013.
13, Lordship.
19/8/2013. Then date of birth will be date of birth of the deceased, 2/1/1961. I think the rest will be remaining the same. Send me the file also, okay, along with the file, I'll check. Disposed.
Matham.
My lord, I'm seeking some intelligence, my lord. Item, my lord, for 30, my lord. Let this matter come after 4 weeks, my lord. There are some developments, my lord.
You are for the department?
Department, my lord.
Which department is this?
My lord, this is tribal affairs.
Tribal?
Tribal affairs.
Mr. R. Dhar, Learned Standing Council, Tribal Affairs Department, submits that he needs some time to get instructions in the matter. And prays for adjournment for
4 weeks, my lord.
4 weeks. Have you informed the other side?
Yes, please, my lord.
Lordship.
Since
Can you do
the-
3 weeks, Lordship?
My lord, order has to be passed, my lord. So that's why I said 4 weeks.
Since the prayer is not objected to by the other side, registry to list this matter again after 4 weeks on a date to be fixed by the registry.
Much obliged.
Okay, we'll assemble at 2 again. Today is basically a motion day. The motion is not finishing.
Lordship, item number 46, Lordship, we have filed one appeal against the writ petition, Lordship. So sometime may be granted, Lordship, notice has been issued, Lordship. In original order of the writ petition, contempt case, 46. Petitioner is also here.
After 17/9 of but said retable fix on 17/9, my lord.
Deliberations states.
What is this IA?
I for delay confirmation.
Writ appeal is registered?
Serial
not yet
number
raised.
has been,
It is submitted at the bar that who has filed appeal?
we have BTC of.
BTC authorities have filed writ appeal for the division bench of this court, which is due to be considered on
17-9.
17/9/2025. Stop in view of above this matter after 17/5,
9.
17/9/2025.
Oblige.
Deeply. 46.
Yes. What do you say, Ms. Quirk?
Lordship, the matter, with the matter, though there is an order of the Honorable Court of 2002 Lordship, the matter was placed before the DLC at 2021 only. So Lordship, I think I need to obtain instruction from the DC, because during the lapse of the time, Lordship. Because why they take 19 years to place the matter before the DLC, Lordship?
So you'll question the DC,
Yes, Lordship.
why you have belatedly considered.
Yes, Lordship.
Page 32 is the DLC minutes.
Lordship.
Any reasoning is given?
No, Lordship.
Yes.
Mr. Counsel, library after 1 week. Let's join it. On the request of Ms. S. Quar, Learned Government Advocate, matter stands adjourned for 1 week to enable her to obtain instructions. Regarding the delay, in considering the case of the petitioner. On 21/12/2021, where the DLC South Salmara, Mankacha had sat. Since the direction was given, continue, no full stop. By the High Court, by this court, way back in 24/9/2002, in WPC number 6084 of 2002. This taken after a week on a date to be fixed by the registry. In the motion column.
That may be fixed, Lordship.
They'll fix a date.
Plus.
Yes,
Lordship, two advertisement was issued by the respondent number 2, Lordship. Pursuant to that advertisement, which is now applied for the post of graduate teacher science, Lordship. And thereafter, he participated in the process of selection process. Appeared in the TET exam, and thereafter, while the document verification was done, at the first instance, her candidature was accepted, but subsequently it was rejected. I take your Lordship to page 38, annexure 7.
yes.
Page 38, annexure 7, Lordship. Her candidature was accepted. Lordship, kindly
accepted for further processing for graduate teacher science post.
Yes.
Below Lordship, diploma in Bengali issued by the Barak Ubitaka Bongo Sahitya and Sanskriti Sammelan. So that time it was accepted, and then your Lordship on 17/7/2025, it was rejected, Lordship. That is at page 39 NHR 8. Rejected verification status for graduate teacher science post. Date of issue of provisional mark sheet of diploma in Bengali is after the date of closing of the online application, that is on 20/11/2025.
Lordship, on the similar cases, Lordship already issued a judgment, Lordship. In that, I have given that copy, Lordship rejected all those cases on the same ground, Lordship. They were submitted after the cut of that, Lordship.
But in the other case, Lordship, that is not accepted. But here in my case, it is accepted at first and subsequently it was rejected without any opportunity of affording any opportunity of hearing, Lordship. And in the advertisement, Lordship,
For acceptance letter to put.
page 30.
One is 1/7, the other is 17/7. Span of 10 days. Isn't it? Where's the advertisement?
Lordship, page 13.
Is this the same advertisement?
Hey,
Lordship.
same as them,
Same.
Lordship. Last date of filing of document was the 2011/2024, Lordship.
But in the advertisement, no such condition was
it was
stipulated,
subsequently,
Lordship.
Addendum was given. That was not annexed here.
Yes, addendum also there. Addendum is there. It is at addendum page 25.
This is regarding qualification, regarding last date of submission, there is another. It is there. Up to 15 numbers.
Yes, we have, I have considered the other case also,
Yes, yes,
similar
exactly.
lines.
Similar
But in this case,
Seems to be
Lordship,
covered.
once accepted and subsequently rejected.
No, why not?
Without affording any.
No, if it's accepted, wrongly accepted, then
Yes, Lordship.
we are concerned with the last date, that's all.
Yes.
It may have been somehow inadvertently accepted. Mr. Chisti, what to do? You want to take instructions?
Similar case of Lordship.
Okay.
Yes. Exactly similar.
Lordship may issue notice.
On the last date of.
Notice for what?
They don't have the qualification on the last date of
Lordship,
filing of.
but,
There's no question of issuing any.
We'll
notice.
dispose it of then.
Yes, Lordship.
Heard, Mr.
LR
L.R. Majumdar, learned counsel for the petitioner, who submits that the grievance of the petitioner is that her candidature for the post of graduate teacher in science in Bengali medium for government as well as provincialized secondary school was accepted. By the acknowledgement issued to her on 1/7/2025. But later on, by another acknowledgement slip dated 11/7/2025, her candidature was rejected on the ground that the date of issuance of provisional mark sheet of diploma in Bengali was after the date of the closure of the online application, that is 2011/2024. So Mr. SMP Chisti, learned standing counsel,
For a second year.
secondary education, submits that in a case of similar nature, this court had declined to entertain the writ petitions filed by the petitioners concerned
and issued an elaborate order, Lordship. It's a detailed order.
And the present case is squarely covered by that decision. Stop in support of his submission, the learned standing counsel has produced copy of the order dated 1/8/2025, passed by this court in WPC number 3929 of 2025, open bracket, Nayan Sharma and others versus State of Assam and others.
And that's it, Lordship. There are other representations also.
Which is, was it a common order? No.
Yeah, it is a common order in 5 cases.
Which was a common order covering 5 cases. Stop upon perusal of the materials available on record and upon hearing the parties. This court is of the view that case of the instant petitioner is squarely covered by the earlier decision of this court. And therefore, court finds no ground to retain the instant petition, and therefore the writ petition stands disposed of, dismissed.
All right.
May it please, Your Lordship.
Yes.
Lordships, a very interesting issue pertaining to a departmental proceeding arises. But prior to that, I'll just briefly state the Lordship, the facts that has reached, the facts that has preceded this writ petition. Now, I am a inspector of schools and I was appointed in 2011 pursuant to a valid selection process. I, along with 15 other people, were appointed. Now, those appointments came to be challenged by persons who could not make it to the merit list. The challenge was laid in 2012, and finally in 2024, the learned single judge adjudicated on the challenge. The learned single judge did not set aside our appointments, but directed the department to conduct an inquiry. Against which we went up in appeal. The writ appeal affirmed the judgment of the single judge, against which we went up to the apex court. The apex court dismissed the SLP in limine. So that is essentially, the learned single judge in the first round directed that an inquiry be conducted. May I just point out those paragraphs which may be relevant for this round of litigation? Would Lordships kindly come, the single judge's order is annexure 1, and would Lordships come to para 52?
Which?
Para 52 starts at page 52. That is the operative part of the single judge's order. Page 52, para 52.
Yes.
May I place it?
Yes.
Regard being had to the maintainability of the present writ petitions on the ground of existence of disputed questions of fact. In the facts of the present case, I am of the view that there is absolutely no bar to entertain the writ petition as the relevant consideration to such proposition is to the effect that whether in a given case, the facts is so disputed which requires taking of evidence to establish the case. In the present case, the facts are not disputed and the allegations of submission of fake experience certificate to secure appointment are prima facie established on bare perusal of the charge sheet. Thus, it would not be appropriate to non-suit the petitioners and hence the writ petitions are maintainable. Now, the court said the writ petitions are maintainable. However, as the charge sheet being a report is nothing but a piece of evidence and it forms a mere opinion of the investigating officer on the materials collected by him, the truth of which can only be decided by the trial court after full trial, it would not be appropriate to interfere with the selection and appointment of the private respondents basing on the charge sheet. Therefore, in my view, it may not be safe to declare the private respondents have submitted fake experience certificates to secure their appointment basing on the said charge sheet. But considering the attending fact situation, certainly the respondent authorities ought to have paused an inquiry on the entire matter. Kindly mark this, Lordships. Then, Lordships, at para 54.
Yes.
In view of the discussion made herein above, I am of the considered view that the writ petitions are maintainable as the materials brought on record creates doubt on the experience certificate submitted by the private respondents. At the same time, in view of the proposition of law laid down by the Honorable Supreme Court, in my view, it would not be appropriate to declare that the experience certificates submitted by the private respondents as fake, basing on the charge sheet filed by the CID against the private respondents, as the guilt or otherwise of the private respondents is a matter of trial before the trial court. Thus, I am of the view that at this stage, without interfering with the selection and appointment of the private respondents, it would be appropriate in the interest of justice to direct the respondent authorities to cause an inquiry. Accordingly, it is directed that the Commissioner, Department of Education, Government of Assam, shall cause an inquiry into the matter and pass consequential orders thereafter in accordance with law within a period of not less than 2 months from the receipt of the copy of this order. Now, this is what the single judge said, and which has been affirmed all through lordships.
Were you a party to this writ petition?
Yes, yes.
You were the petitioners.
We were the private
Oh,
respondent.
you were the private respondent.
It was our appointment that was being assailed.
Okay.
So now the single judge says, please cause an inquiry.
Hmm.
And as I have said, Sir Lordship, this order has been affirmed right up to the Supreme Court.
Hmm.
So there is no dispute on that. Now, the Lordship, the issue that Lordship arises is this. The Assam Disciplinary and Appeal Rules, 1964, doesn't perceive of a preliminary inquiry. It perceives the statutory position in terms of the rule is that you initiate a Rule 9 inquiry. The High Court has also met that an inquiry under Rule 9, which is contemplated under the discipline appeal rules, need to be initiated against these people. My first contention is this. The scheme of the rule and the safeguards, inbuilt safeguards in the rules have been completely given a go by, which I will demonstrate from the record. Neither was I allowed to cross-examine, neither was I allowed to produce any witness, neither was I allowed to produce any documents. They just called the people, took their statements, and thereafter recorded their findings. Now, what is interesting here is this. They initiate an inquiry. In the inquiry, as I have told you, Lordships, that nothing was followed in terms of Rule 9. They record certain findings, conclusive findings, that yes, your certificate is fake. You have not served the period of experience that was required by the advertisement. And thereafter, issues me a show cause under Rule 9. First, they do an inquiry, and thereafter, after conclusion of the inquiry, issue a show cause. Now, against the show cause, I submit a substantive application to them, a representation, taking up issues both on facts and law. My first grievance is Annexure 12. That representation came to be rejected by a single word, your application is rejected. Please come, Lordships, to Annexure A11. Page 95. In fact, Lordships will first come to Annexure, the show cause notice, which is at page 79. So here, what I am trying to say is, Lordship, if I may make myself clear, there is an inquiry. Post their inquiry, you issue me a show cause notice for another inquiry. Is that the statutory position? Now, this is the show cause notice. Upon receipt of the show cause notice, I file a substantive objection to this, which is Annexure 11, page 95. I will just like to take my Lordships to the objection that I filed. What was my grievance? At page 95. Permit me to please place this entire representation. Sir, I am in receipt of the show cause notice and statement of allegations bearing so-and-so dated 26/3/2025 issued to me. This is to state that the same is illegal and thus non-est in law. The show cause notice has been issued without any authority of law and in violation of the statutory rules, as well as the judgment and order dated 27/8/2024 passed by the learned single judge in so-and-so. Hence, I wish to assail the same on the following amongst other grounds, which are taken without prejudice to one another. That it is the humble understanding of the petitioner that the inquiry directed by the learned single judge at para 55 of its judgment dated so-and-so has to be logically construed as one that is contemplated under Rule 9 of the Assam Services Discipline and Appeal Rules 1964. Be it stated that the aforesaid rules do not prescribe and or authorize any preliminary inquiry prior to a Rule 9 inquiry. Kindly mark that, questions. The aforesaid inquiry under Rule 9 has been conducted and concluded upon submission of the inquiry report dated 10/12/2024. Hence, there was no occasion now to again issue a show cause notice purportedly under Rule 9 of the Assam Services Discipline and Appeal Rules 1964, read with Article 311 of the Constitution, wherein I have been asked to show cause as to why any of the penalties prescribed in Rule 7 of the Assam Services and Discipline Appeal Rules 1964 should not be inflicted upon me. The inquiry already concluded is also unsustainable in law, inasmuch as the mandate of Rule 9 inquiry has been given complete go by. The petitioner has been denied the right to cross-examine the witness, whose statements have been relied upon by the inquiry officer. Even the documentary evidences which have been relied upon by the inquiry officer has not been given to the petitioner, causing grave prejudice to him. The inquiry officer in a report dated 10/12/2024 has recorded the following categorical finding for the petitioner that by no stretch of imagination can be said to be prima facie or tentative. Considering all statements and documents submitted during the inquiry process, it is evident that the experience certificate submitted by Anup Kumar Das, who is presently posted at IS Goalpara from Tiwanagar High School for a period of 2/9/2002 to 3/4/2010 is fake, which the headmaster of that school, Sri so-and-so, has admitted. This is wrong. CID report reflects the same conclusions. A perusal of the above clear finding will make it obvious that the illegal inquiry conducted was not in the nature of a preliminary inquiry, even though the authority would like to contend so. This is because the main purpose of preliminary inquiry is to determine whether or not there is a prima facie case against the official for proceeding further against him. Preliminary inquiry is in the nature of a fact-finding inquiry. After the conclusion of a preliminary inquiry, a brief note of the proceeding should be prepared in writing. The inquiry should conclude into a report which should contain the findings as to whether there seems to be some substance in all or some of the allegations and to what extent a particular employee is responsible, instead of recording categorical findings of guilt against an employee as has been done in the instant case. That in regard, I would like to further draw your attention particularly to the following statement incorporated in the show cause notice. While inquiring into the matter of selection of IS Deputy Director by advertisement dated so-and-so in pursuance of the Honorable High Court's order dated so-and-so in WPC, it has been found in the inquiry that while applying for the post of ISDEO, it is evident that the experience certificate submitted to you from Tiwanagar High School for the period so-and-so is fake, which the headmaster of the school, Sri so-and-so, has admitted. CID report reflects the same conclusion. As per CID's report, a record shows that you were not a regular employee of Teachers Training College, Mirza. It is also clear from the above aforesaid views are in no manner prima facie findings. Rather, they are conclusive findings recorded against the answering respondent by the inquiry officer without first affording him a reasonable opportunity to defend himself. Therefore, the attempt now of the authority to issue a show cause under Rule 9 of the Assam Services Discipline Appeal Rules 1964, read with Article 311 of the Constitution, is nothing but an abuse of the process of law. It is being done to just create a smokescreen, inasmuch as the decision to inflict punishment upon the petitioner has already been taken. The decision, Lordships?
Yes, to take
Show cause.
to inflict penalty.
Yeah, that is the show cause notice. Please come to the show cause notice, the first paragraph itself. Page 79,
Which part?
first paragraph. Sir, you are hereby required to show cause under Rule 9 of the Assam Services Discipline and Appeal Rules, read with Article 3(1) of the Constitution of Assam, as to why any of the penalties prescribed in Rule 7 of the aforesaid rule shall not be inflicted upon you on the following charges based on the statement of allegation attached here.
So this is the beginning only.
No, so therefore, this cannot be done. Rule 9(2) doesn't contemplate this. I will show you the rules documents. Rule 9(2) doesn't contemplate this.
Now, how does Rule 9, how does the inquiry begin? By way of show cause, isn't it?
Yes, lordships. Show cause will only have to contain the charges and the statement of allegations, nothing else. And if I may take lordships to the other paragraphs of this show cause, it is very evident that they have already decided, even before the charges were proved, that my testimonials are fake and whatever I am saying is wrong. If lordships will come to the other paragraphs of the show cause.
What is this list of documents, inquiry report submitted by letter so and so? At page 81,
Page 81.
serial number 1.
These were the documents that were annexed to the inquiry report.
Inquiry report submitted by letter number so and so.
These are the documents annexed to the show cause notice,
Which show cause notice?
which was served to me, this one.
No, list of documents. Of course, this is annexed to the show cause, but it speaks about some inquiry report already.
Yes.
Where is that?
That is the inquiry. That is the inquiry report, lordship, that page 10, annexure 10, page 84. That is what I was saying. An inquiry was done, and therefore thereafter a show cause is issued. The whole process has been reversed. Which starts from page 85.
So how was the inquiry initiated earlier?
How the inquiry was initiated? The answer is, lordships, at page annexure 4, after the High Court judgment,
Yes.
the writ petitioners filed an application before the respondent authorities. And that is at page 72. If lordship will see prayer for issue, these are the original writ petitioners who had assailed our selections, on which the High Court says, please cause an inquiry. If lordship, I recall that single judge's direction.
Single judge says you can make an inquiry.
Yes.
So was inquiry done?
This is the one.
Which one?
Which I just showed, page 81.
81.
Annexure 10. Sorry, page 84, annexure 10.
It just says submission of inquiry report.
No, that is the covering letter. Next page.
Okay. Inquiry report. 28 October.
Yes.
28 October 2024.
Yes.
Then.
This is the inquiry which we say is essentially a Rule 9 inquiry.
This 85 is a Rule 9 inquiry.
Has to be, because there is no other inquiry in the Assam.
What is the conclusion and finding?
Yes. Finding with respect to me, they had inquired about 3 people. I am only concerned about Anup Das. And the finding is that page, it starts from page 92. Page 92. And my findings are from page 93, considering that paragraph, lordship, the considering all statements. Page 93, if lordship will see.
So, see, page 85 is the inquiry report.
Yes, lordship.
And they refer to the High Court's order.
Yes.
So this perhaps may be the inquiry under Rule 9.
Yes.
Now, after the inquiry report is submitted, a copy is invariably given to the delinquent officer.
Yes.
This is the inquiry report against you.
The inquiry has to be preceded by a show cause notice. Where is the show cause notice? Where are the charges? Where is the statement of allegation? If lordship will kindly see Rule 9, it will be clear. Kindly have a look at Rule 9, how Rule 9 proceeds. Please have a look, Lordships. Ekon deduction.
I have it here.
Rule 9, Lordships. May I place this? The
Yes.
entire scheme. Procedure for imposing penalty. 9.1, without prejudice to the provisions of the Public Servants Inquiry Act 1850, no order imposing on a government servant any of the penalties prescribed in Rule 7 shall be passed except after an inquiry held as far as may be in the manner herein provided. 9.2 is very, very important. The disciplinary authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges, together with a statement of allegations on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit within such time as may be specified by the disciplinary authority a written statement of his defense, and also to state whether he desires to be heard in person. There is no show cause notice.
I understand. See, what they have done is that they have relied upon this paragraph 55 of the judgment. Court said you should have an inquiry within 2 months, finish it.
So I didn't.
So what perhaps they should have done was issue a show cause under Rule 9 and I'll follow this entire procedure.
And now what they've done, they've inquired, and now issued a show cause after the inquiry. So I'm not even able to defend myself.
Yes, anyone from the state? See, understanding of the respondents was paragraph 55 of the judgment of the learned single judge. Accordingly, it is direct the Commissioner, Department of so-and-so shall cause an inquiry into the matter and pass consequential orders. So some inquiry was done. Oh no. Then 85 came, inquiry report. Along with this inquiry report, now the show cause and 9 comes. And closing that report.
Inquiry was conducted
some
as
procedure-
per the Honorable High Court order, my lord. And subsequently, my lord.
So I have not been able to I have not been given an opportunity to cross-examine the witnesses. Nothing, Lordships. This is precisely what I have stated in my representation. And see how they have, Lordship had seen this representation, now see the way they've responded to the representation is even, if Lordship will kindly come to Annexure 812, page 100. Lordship have seen my representation, I've raised those issues. Now kindly see page 100. What they say. This is the disposal of my representation.
100.
Yes. With reference to the subject cited above, I am directed to inform you that your prior petition dated so-and-so has been rejected by the disciplinary authority and directed you to submit a written statement of your defense to the department within 7 days, failure of which the disciplinary authority shall proceed as per provision of Rule 94 Assam Service and Discipline Rule 1964. That's all. No reasons at all. Why you have rejected?
How was this inquiry report prepared? You were not part of the inquiry. You did not participate.
No, I did give my statement.
You did the inquiry.
My statement was recorded in writing. They also call other witnesses.
Then?
And they took their statement, didn't permit me to cross-examine. And that is obvious. If I may read the inquiry report, it is obvious the way they have proceeded. Even the High Court says that you cannot rely on the CID charge sheet. They completely rely on that.
Where is your statement that you have not been allowed to cross-examine?
Yes, that is my objection, which I have filed.
In the writ petition?
In the writ petition?
Yes. Have you mentioned that?
Yes. We have writ petition of process. Para 17 page. Lordship will kindly see page 17. Para. In fact, Punto page. Para 17, page 17.
Yes, I've seen it.
And Lordship will kindly appreciate one more aspect. If Lordship will kindly see the show cause, if I may be permitted to place the show cause notice, there is a prejudgment of guilt, which cannot be. There are enough judgments of this court and the apex court which says that when the disciplinary authority proceeds.
Correct. See, the language should have been, you have violated so and so, so and so.
You're now saying that you will inflict this punishment on him. So what sort of inquiry is this?
We'll examine the matter at this stage.
Please.
We'll issue notice.
Please do, Lordship. And
All right.
Lordship may kindly stay
All right.
the proceedings.
Art, Mr.
I am Manish Goswami.
M. Goswami, Learned Senior Counsel, assisted by Mr. R. Sinha for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the show cause notice issued to him on 26/3/2025 by the Secretary to the Government of Assam, Department of School Education, wherein the petitioner has been asked to show cause as to why any of the penalties prescribed under Rule 7 of the Assam Services, open bracket, discipline and appeal, close bracket, rules, 1964, open bracket, rules of 1964, close bracket, shall not be inflicted upon him. Stop. The Learned Senior Counsel submits that, in fact, three persons had approached this court earlier by filing WPC number 4325 of 2012. No, a number of persons. Okay. Not only one, isn't it? This is a.
There were two writ petitions, Lordship.
Okay. 4 persons. Okay. 4 persons had approached this court on earlier occasion by filing WPC number 4325 of 2012 and WPC number 7378 of 2013.
Yes,
On the allegation that the present petitioners had secured their appointment as
Inspector of Schools.
Inspector of Schools by producing fake experience certificates. To stop, the instant petitioners were arrayed as private respondents.
Lordship, I am just one petitioner here. There's just one petitioner.
Okay, okay. The instant petitioner, not S, was arrayed as one of the respondents. Stop. The writ petition came to be disposed by the common order dated
27/8/24.
27/8/2024. By directing the respondent authority concerned to cause an inquiry into the matter and pass consequential orders in accordance with law within the time frame. Stop. According to the Learned Senior Counsel, instead of following the 11 provisions under the rules of 1964, the department proceeded by inquiring into the matter, and during such process, although witnesses were examined, the petitioner was not allowed to cross-examine the witnesses. Stop. Thereafter, why the impugned show cause notice dated 26/3/2025, the petitioner has been asked to show cause as to why he should not be punished in terms of the relevant provisions of the rules of 1964. Stop. The Learned Counsel submits that the Rule 9 of the rules of 1964 has been flouted by the respondent authorities themselves by coming to a conclusion with regard to the guilt of the petitioner even before an inquiry is done in terms of the said rules. Stop. Accordingly, the Learned Counsel submits that the show cause notice and the inquiry report should be set aside. Next, para review of above, issue notice of motion returnable by 4 weeks. Lister, B. Talukdar, learned standing counsel.
Department of School Education.
Department of School Education accepts notice on behalf of respondent numbers.
Order.
Accept notice on behalf of all the respondents. Stop. As such, formal notice is not required. Stop. However, petitioner to serve requisite copies of the writ petition to the learned standing counsel within 2 working days.
Lordship, the interim relief that we are seeking is at page 22.
What is that?
That is, the proceedings may not proceed.
Next para, having regard to the projection made by the petitioner, in the interim, they have provided that till the next returnable date, the respondent authorities shall
22-1.
ten, 12, 24, is it? What is 10, 12, 24?
That is the inquiry report, Lordship.
Shall not take any coercive steps
Yes.
pursuant to the inquiry report dated
Inquiry report is
Twen-
dated, Lordships, 28-10-2020.
28/10/2024.
Lordship is state the proceedings, Lordship.
That's what, shall not proceed. That's what I said. List the matter again after 4 weeks on a date to be fixed by the registry. Respondent shall file their counter affidavit in the meantime. Yes.
Extremely grateful, extremely.
May it please your lordship.
Yes.
My lord, the petitioner herein is aggrieved by the impugned gradation list, the final gradation list of teachers and employees under SCERT, which your lordship is aware, which covers 3 wings. Now, the petitioner is an assistant teacher of a normal school. These schools are meant for providing teachers training, as your lordship is aware. Now, your lordship will kindly.
SCRT party. SCRT party. Lordship, there is a slight error in this case, my lord. The SCRT is the main party in this matter. The SCRT, though he has made the party in the petition, in the cause list, it's not reflected. Can you see? It's only SC elementary. So the main necessary party is the
We
SCRT.
have served copy while filing the case, but the name might not have been shown. Anyways, my lord, let me place my case. After that, my lord will today perhaps issue notice. We'll serve copy upon that. Now, my lord, what has happened is in the gradation list, which is impugned at page 31, the petitioner who was appointed along with private respondents number 4, 5, and 6 on the same date, 19/11/2019. Now, they had different dates of joining. Your lordship will, my lord, find page 31, which is the gradation list impugned, the final gradation list dated 17 June 2025. The very next page, if your lordship kindly says, I am concerned with serial numbers 25, 26, 27, and 28. Now, 28 is the petitioner before your lordship. And 25, 26, and 27 are the private respondents number 4, 5, and 6. Now, your lordship kindly says, the column
28 is the petitioner.
Yes. And your lordship will kindly see their comparative dates. Now, so far the petitioner's date of here, the date of joining that has been reflected is 20/11/2019. Now, vis-a-vis, your lordship will kindly see the date of joining in respect of 25, 26, and 27, serial number 25, 26, 27. They are all subsequent to the date of joining of the petition.
What is this list?
This is the final gradation list
Of assistant teacher.
no, not only the assistant teachers. It's the final gradation list of assistant teachers, instructors, music teachers, Hindi teachers, Sanskrit teachers, and graduate instructors having of normal schools under the Directorate of SCERT.
But it says provisional.
No, this is in reference to that provisional list. This is the final gradation list. Subsequently, your lordship will see that the line after verification and proper examination of the complaints received from the incumbents thereon, the final gradation list is hereby notified with immediate effect. That is right at the top of the list at page 31.
Okay.
So this is the final gradation. And before, my lord,
So what is your grievance?
my grievance, my lord, now because
Of your
this-
seniority position?
Yes, the inter se seniority position now will be determined on the basis of this list. Now, my humble contention is inter se seniority, when it comes to incumbents having same date of appointment, has to be determined on the basis of their dates of joining and dates of regularization. Now, the list itself makes it clear that the date of joining of the petitioner is earlier in point of time to that of the private respondent number 4, 5, and 6. And my lord, this particular final gradation list is consequent upon a provisional list in which this error crept up. And subsequent to this error in the provisional gradation list, whereby there was a forwarding letter in which objections were sought for. The objection was raised on behalf of the petitioner by the principal of the school itself. Respondent number 3 is the principal of the school who had forwarded the objection on behalf of the petitioner. That is at page 30. At page 30, this is the objection raised on behalf of the petitioner from the school itself, where the principal of the school had come up with an objection in regard to the provisional gradation list in which this error crept up for the first time. But without taking this objection into account or even disposing this objection, the final gradation list has been prepared. Thereafter, I again preferred a representation, even that has also not been attended to. That representation is at page 33, my lord. And my lord, one aspect which I would like to draw your lordship's kind attention to is the fact that prior to this exercise of provisional list and final gradation list, there was a final gradation list of the year 2021 that your lordship will kindly see. There is another gradation list which was earlier in point of time. That was of 25th October 2021 that your lordship will find at page 24. That your lordship will find.
Come to the
Yes,
list.
24. The relevant portion your lordship will find at page 26.
Where are you?
I am at page 26. This is the
Serial number? Serial number?
Serial number. I am 29, and those who are now above me, they are at 30, 31, and 32.
Okay.
So there was already a final gradation list.
They are a private respondent here in your.
Yes, they are the private respondents here, and they are the ones who are now above me in the impugned final gradation list. Now, this is the final gradation list of 2021, and this was the position. Now, how this could have been altered subsequently in a span of 3 years with the
It appears that the reason for such alteration is like in terms of what the principal has detected.
My lord,
It's as per the date of birth.
Which is not permissible.
Not date of joining, but date of birth. The earlier one was as per the date of joining.
Yes. Now it has been done as per date of birth, which is under the law, and under the relevant rules not permissible in my humble contention, my lord. And that is the reason why I am before your lordship. There are several rules to that effect. One such rule, my lord, which of course is having relevance insofar as SCRT cases are concerned, that is Assam State Council of Educational Research and Training Promotional Service Order 2020. Now, this I have, my lord, procured. This is one relevant rule in which it says, when in case of determining interstate seniority, there is no extension of the time of joining, then the interstate seniority has to be determined from the date of joining. So this is one rule.
Okay, you all are working under the SART.
Yes, my lord.
Okay. Will issue notice?
Yes. And my lord, I have one more prayer that, of course, my lord, can be taken care of after a response comes. I have a small interim protection, my lord, that I am praying for, that this particular final gradation list may not be acted upon for the purpose of promotions, my lord, in the course of affairs, because otherwise, if there is a cause of.
I have objection, doctor. Here the impugned list was issued by the SCRT authority. I am appearing for SCRT on being informed by one of my colleagues, doctor. My name is not appearing in the court list. I am not aware of.
My lord, let notice be issued. Let notice be issued. Today I am not present.
To that extent,
today I am not.
Notice lordship, I have no objection.
Heard Mr.
D. Chakravarti.
D. Chakravarti, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the notification dated 17/6/2025, bracket annexure 7, by which the petitioner has been placed
Page 32.
below the private respondent numbers 4, 5, and 6, who otherwise had entered into service after the petitioner. To stop, the learned counsel submits that as per the as per the gradation list that was earlier issued on 25/10/2021, the petitioner was senior and placed above the private respondents. Stop. He submits that although the petitioner had submitted his representation before the director SCRT on 11/7/2025, but seems the same has not been considered. The petition is before this court. In view of above, issue notice of motion returnable by 4 weeks. Mr. P. Nayak, Learned Standing Counsel. SCRT accept notice on behalf of respondent numbers.
I am appearing for 2 on the document.
Respondent number 2.
Yes.
Well, Mr. A. Fugan, Learned Standing Counsel. Elementary Education accepts notice on behalf of respondent number 1. Petitioner to take steps for service of notice upon the respondent numbers 3, 4, 5, and 6 by registered post with AD due within 3 working days. Stop. Petitioner shall also serve requisite copies of the writ petition to the learned counsels appearing for the respondents today. Stop. Next para, issue notice to the interim on the interim prayer as well, returnable by 4 weeks. Learned counsel for the respondents to obtain instructions so that the same can be considered on the next returnable date.
May I pray for a date after 4 weeks?
They'll fix it. The registry shall list the matter again after 4 weeks on a date to be fixed by it.
Maybe. Petitioner, my lord, participate in the selection process for the post of graduate teacher and appeared for verification on 30/7/2025, my lord. And on that day, my lord, annexure 7, page 34, my lord, his candidature has been kept on hold due to certificate.
Where's the advertisement?
Advertisement, my lord, here. At page 20, my lord.
20.
Yes, my lord. Pursuant to that advertisement, he participated and that has been his written examination he has passed, my lord, and page 32 is the call letter for verification. And on that day he appeared.
Graduate teacher in what subject?
Graduate teacher in arts.
Arts.
Yes.
Where were you called? By which letter?
My lord, page 34. Page 34.
No, 34 is hold to
Hold,
due
yes,
to certificate.
due to certificate.
What does it mean?
But the process is not further, he has not given clearance in the verification as on date. And due to certificate.
It's either reject or allowed, isn't it? What is hold?
Neither rejected nor accepted. It is under hold.
Mr. Kaushik, you have put the petition in suspension.
My lord, it appears.
Either allowed or reject, neither allowed nor reject.
No,
It's
it
hold,
appears, my lord, it has been withheld, my lord.
kept
for-
in abeyance.
Withheld for verification because the verification process is still going on. Lordship will take up on Monday, my lord. Let me get the instruction.
So is it premature then, your case?
No,
It's not rejected.
Not
it's kept on hold, my lord. Kept, it has to be either accepted or rejected. It cannot be kept on the hanging position.
Heard Mr. B. Prokasta. B. Prokasta, learned counsel for the petitioner, who submits that the petitioner participated for the post of graduate teacher in arts. And he was called for, she or he? He was called for verification of his documents. However, the respondent authorities, for reasons not known to the petitioner, has put his candidature on hold due to certificate. Something wrong with the certificate?
Nothing wrong, my lord. On that day, my lord, he could not produce this NCT recognition or order, my lord. From where he has passed the B.Ed degree and subsequently has procured it.
When will you get instructions?
Anything, my lord, next week, anything.
Will issue notice or what?
I not required, my lord.
Not required.
Let me first have the.
Mr. B. Kaushik, learned counsel for the learned standing counsel, secondary
Second.
education department, shall obtain instructions by the next date. Mr. B. Prokasta shall furnish an extra copy of the writ petition to enable Mr. B. Kaushik to get the instructions. This matter again on so and so. 22-8.
Obliged.
May it please, my lord.
Yes.
The petitioners before your lordship that petitioner is under suspension on 17/7/2025, my lord. He's agreed by lord, his headquarter is changed, my lord, to Sribhumi from his last posting, my lord. I am agree on this part also. Page 20, my lord.
Which paragraph?
Page 20, my lord, suspension order, my lord.
Paragraph.
Yes, my lord.
I think it was the second last paragraph.
Yes, my lord. Bottom portion, my lord.
During the period of
During the
suspension.
period of suspension, his headquarters shall be fixed at Dayat Sribhumi. And he shall not leave the station without obtaining prior permission from the, I am agreed only this portion.
Where are you otherwise posted?
Yes, my lord, Lakhimpur, my lord. Last posting, my lord, Lakhimpur. I am suspension from Lakhimpur, my lord.
What is wrong? What is wrong in this?
Yes, as per rules, my lord, the manual of departmental proceeding, my lord, rule number 2.7.2, my lord.
Read, what does it say?
Yes, my lord. An officer under suspension is regarded as subject to all other conditions of service applicable generally to government servants and cannot leave the station without prior permission. As such, the headquarters of a government servant should normally be assumed to be his last place of duty. Where an individual under suspension requests for a change of headquarters, there is, however, no objection to competent authorities changing the headquarters if it is satisfied that such a course will not put government to any extra expenditure like grant of traveling allowance, etc., or other complications.
So you filed representation.
Yes, my lord, I have already filed, my lord.
Let them consider it then.
Yes.
Mr. Bora.
Page 21, my
Oh. You consider and dispose of it within time frame.
Yes, page 21, my.
Heard Mr.
M. Kolita.
M. Kalita, learned counsel for the petitioner, who submits that being agreed with the order dated 17/7/2025 bracket annexure 2, insofar as the fixation of the petitioner's headquarters during his suspension period is concerned, is before this court. So the learned counsel referring to, what is that provision?
Yes, my lord.
Referring to rule,
The manual of departmental proceedings rules 2.7.2.
rule 2.7.2 of the manual on departmental proceedings. That much only. Dr. B. Ahmed is the author of this book.
Yes.
Hmm? Submits that ordinarily the place of stationing of the employee kept under suspension would be the place of his,
Last day.
the place where he has been posted last. To stop, the learned counsel submits that the petitioner was last posted in Lakhimpur, and the respondent authorities ought to have stationed him in that place only. Next para, a perusal of the provision referred to by the learned counsel goes to show that it is no, I'll not make that observation. Next para. It is seen that the petitioner has preferred a representation. Where did you prefer?
Page 21, my lord.
No.
Page 21, no. Page 21 followed by page
Yes,
24.
yes, ma'am.
Page 24 is the first. Step we receive.
Yes,
The one is the by post.
two representations submitted, my lord. One is page 21 and another is page 24.
24 is the, that will receive by the office.
Yes, reminder. That is reminder.
Has submitted a representation before the secretary to the government of Assam, Department of School Education, on 25/7/2025, and thereafter a reminder on 1/8/2025. Stop such being the position, this court considers that the said representation be considered by the respondent authority concerned on its own merit. In view of above, this writ petition is disposed of by directing the respondent authority concerned, that is the secretary to the government of Assam School Education Department, to consider and dispose of the representation of the petitioner by way of a speaking order, reasoned and speaking order, within a period of
3 weeks.
3 weeks from the date of receipt of a certified copy of this order. Mind you, it is not mandatory. It says may, word is may. So you may be kept anywhere.
Yes, ma'am.
Supposing you have made some mischief in one place.
Yes, ma'am.
If you remain there, then you might interfere with the proceedings. So for that purpose, normally it is posted out elsewhere. That is the reason behind.
That is true, my lord. One judgment of Central Administrative Tribunal that if departmental proceeding is beginning, if the my lord, suspended person threatening the person, witnesses, etc., that my lord, his posting may be transferred, my lord. Otherwise, region order, my lord, that should be, my lord.
So here, before you start threatening others, they have posted you there.
Yeah, my lord.
Anyway, they'll consider and pass orders, okay?
Obliged.
Yes.
Obliged, ma'am. Need to the lordship.
This matter pertains to a similar writ petition which has already been decided by this honorable bench. So this was regarding the issue of cutoff date, the eligibility of the certificates, which has been issued after the cut. The only difference is that here, the petitioners before your lordship is before the postgraduate teachers for the post of PGT, and that was graduate teachers. The judgment is this.
It's covered.
It's covered. Writ petition.
Right, Mr.
K.M. Mahanta.
K.M. Mahanta, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner Mr. K.M. Mahanta, okay, who submits that the petitioner is aggrieved with the rejection of their candidature, petitioners S, of their candidature as postgraduate teachers on account of having B.Ed certificate / mark sheet of fourth semester after the last date of application stipulated to be submitted online. To stop at the outset, it is submitted at a bar that this court in
WPC number 3929 of 2020.
WPC number 3929 of 2025,
Leading to. This is the leading.
which is the leading case, involving similar issue in respect of graduate teachers had declined to interfere with the rejection of the petitioners therein, which was also due to the obtaining of the certificates required after the last date stipulated for submitting the application online. To stop such being the position, this court finds that there is no requirement to enter into the present controversy, since the issue has already been settled. Accordingly, the writ petition stands dismissed. Mr. B. Kaushik, learned standing counsel, secondary education, appears for the State Department.
Lordship, I have a small prayer with regard to item number 24.
Yes.
That matter has been posted after the matter was kept for judgment by a coordinate bench, but nonetheless, let this matter be taken up after 2 weeks, Your Lordship.
You're taking your chance. Item 24, right, as paid for by the learned counsel for the petitioners. List this matter for admission after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
This was fixed at 2.
Yes.
So it has become infructuous now.
Yes, Your Lordship. Please, Your Lordship, continue.
Yes.
My lord, this matter pertains to MBBS BDS course, my lord. In continuance of earlier submissions, my lord. Already.
Any additional submissions to make? I have heard you already.
Yes, Your Lordship. I want to submit, my lord, that the 5% reservation for government student who have studied in government schools.
5% should prevail. They should give us 5%.
Yes, but
benefit.
I want to say, my lord, that reservation provided to them because they are struggling and they are facing various hurdles, and to leveling that playground, my lord, the provision.
So that means studying in government school You faced a lot of problems.
Yes, my lord.
So for the problems and sufferings you had, you should get 5% reservation.
For encouraging them, my lord, to
Mr.
study.
P. Gogoi, what has happened to the standard for government schools?
My lord,
People feel that they are suffering in studying in government schools.
that, my lord, of course, not the previous case, otherwise we would have replied.
No, the very fact that that reservation is given, that shows that there is some disadvantage.
They wanted to go, there was a policy decision of the government which was there in 2024. Now, my lord, that has not been continued. For 1 year it was given and subsequently not.
Private schools are more popular than government schools. Is it?
I won't comment to that, my lord.
So he started by his argument by saying that all the sufferings we had
Yes,
studying in the government schools.
Quota. Some of the guilds are.
that is for economically weaker purpose, my lord. My lord, as my,
So that is your case. What else is there? We'll take a call this way, that way.
yes, my lord, almost.
Only thing, my lord,
yes, my
even,
lord.
my lord, that only said the case, my lord, which the honorable Supreme Court has said, my lord, on the day of counseling. Before the last date of counseling, one must have this. Counseling starts, my lord, under the Director of Medical Education by the 1st of July notice. So now she will see that, my lord, in 2003, it is the state who is to conduct the, my lord, counseling. In 2003, my lord, way back in 2003, there is a joint entrance examination, JEE. This mentioned in the judgment also. Now, my lord, after that, immediately counselings are held. So that last date of counseling will be applicable at that point of time. Now, here, my lord, it is the NEET who is to conduct the particular, my lord, the entrance examination. They prepared a list and they used to distribute it to all the states for the state quota 6. 15% all India quota, they used to conduct it by themselves. That is, my lord, MCC, Medical Counseling Committee. That too, my lord, which has been constituted by the Director of Health Services Union of India. Quota 15%. 85% is entirely upon us, my lord, as per our regulation. In fact, my lord, Lordship will see that 2017 regulation, which is part of the academic reply, there is the eligibility criteria prescribed there. They will have to fulfill that, my lord, in order to have the, my lord, state quota 6. Thus, having a, my lord, particular rank in the NEET will not, my lord, help them to have a seat under the state quota 6.
My lord, I have no grievance against that submission because, my lord,
Regulation
only
number
question.
3, eligibility of the state quota 6.
That is one aspect, Mr. Gogoi. Other aspect is that he says that since the last date was so and so.
No, that's why
Subsequently,
the difference is there.
subsequently, you can, if you amend it, okay, but it cannot apply to me. This is what he's saying.
No, that part, my lord, that's why I'm saying, my lord, eligibility, I have shown in the information bulletin, eligibility criteria for NEET has been prescribed, my lord, separately in the, my lord, information bulletin for NEET. For the state quota seat, my lord, it is the notification, my lord, that will be issued by the designated the authority of the state, that is the Director of Medical Education. And as per our regulation, my lord, we will, my lord, verify whether this particular candidate who has, otherwise, he has scored some rank and, my lord, eligible to participate in the counseling, whether you will be, my lord, getting a seat under the state quota. So our regulation will come into force at this point of time. So that notification of 1st of July.
See, your regulation of 2024 is welcome. Only thing is that petitions that 2025 has been applied to me.
24 is applied, my lord.
That is the crux of the matter, I think.
Yes, your lordship.
Because, my lord, not only particular R, my lord, 5.1 R has been, my lord, left out in, my lord, so far as the 2025 amendment is concerned. But in more other amendments have been brought in, my lord. Following that, we are holding the counseling. And in the, my lord, educational notice, we have stated it will be as per the 25 regulation, amended one.
Okay.
That,
So I'll consider and pass necessary orders, okay?
Lordship.
Since I have some few matters left, we'll take up that matter.
Yes, your lordship.
This I'll pass the orders later on in chambers. It will not be CAV, okay?
Yes, your
You'll get
lordship.
the order by, hopefully by tomorrow.
My lord, I just point out one another
Lordship will
additional
kindly,
point, my lord.
That does mean, my lord, the honorable, my lord, court relied upon in that, my lord,
Which one?
judgment of, my lord, the WPC number, just I want to point out, my lord, 4174 of 2017.
Have you given that copy to me?
No,
Yes,
it's
your
part
lordship.
of the, my lord, the Jolly Sapar is there. So what does it want to get? Let's see, it's a bit better. Lordship will see just, my lord, one citation has been mentioned in, my lord, para 25. It is, my lord, 2005 9 SCC 779. It was relied upon by the honorable court at that point of time. My lord, I am giving a copy of the judgment. Para 7 lordship may kindly show example. But you will see, my lord, para 7 of the judgment which has been relied upon. It says, my lord, para 7, the general rule is that while applying for any course of study or a post, a person must possess the eligibility qualification on the last date fixed for such purpose, either in the admission brochure or in the application form. Here, my lord, that particular last date of submission of application for the admission, my lord, under the state quota was issued sometimes in 1st of July 2017, my lord, or 2025. For, my lord, NEET examination, it was issued in February by the, my lord, National Testing Agency, NTA. But for, my lord, counseling, it is our notification we have given the last date. That you will have to apply within this particular.
Where is your
period.
notification?
Yes, sir. So that process will come only when we have issued the notification.
Where is your notification? Just point out which page number.
Lord, you will find it. It starts from page number, my lord, 160 of the affidavit is the continuation of that, my lord. Running page number 160 of part of our affidavit in operation.
Educational notice.
Yes, sir. This is the first notice that was issued by the state government on 1st of July 25. First notice says about the special quota. Then, my lord, in the next page, this is a particular form. Then again, my lord, the educational notice, my lord, when the dates are, my lord, the specific dates have been given at page 162. Again, 163, and my lord, 164 is the date for counseling. So before the date of commencement of this particular counseling, they will have to have the eligibility criteria.
No, this is already there in the writ petition also.
Yes, yes.
Page 50 and extra 9.
It is there in the disposition. So our, my lord, process started from 1st of July 2025. That on that day, the petitioner will have to have that particular qualification for holding this. Now, my lord, 2017 rule has been made part of the, my lord, affidavit in reply. Just, my lord, one clause, my lord, clause 3.1.c. Yes, Lord, you will see, my lord, page number 218. 218, my lord, the 2017 regulation. This has not been amended. 219, my lord, down below.
Yes.
Eligibility for state quota seats. Following condition must be fulfilled. Lord, you will see it is still, my lord, D, clause D. All these will have to be fulfilled for the state quota seats. So that eligibility will come, my lord, only when the counseling starts in the state of Assam. Just because he has, my lord, he is eligible for appearing the NEET does not, my lord, confer any right upon the petitioner to claim a seat under the state quota without, my lord, following this particular regulation. And, my lord, the main is, my lord, C, 3.1.c. This was put to challenge before the division bench. Honorable division bench has upheld this particular criteria that you will have to study in the state of Assam from class 7 to class 12. That's what I'm saying, my lord. These are the criteria, my lord, from A to C of regulation number, clause number 3.
Okay.
There are other procedures too, my lord.
Consider and pass necessary.
My lord, I like to point out one additional ground, my lord.
Yes.
That the state of Assam provided this 5% quota for medical students as well as to the engineering students, BE and BTech, my lord. Still now, in this session also, this 5% quota provided for BE and BTech candidates, my lord, for common admission test, my lord, but only for medical entrance, my lord.
From where are you saying that?
My lord, in writ petition,
the
I have annexed that the brochure, my lord.
Is a higher education, my lord, not us, my lord. Health department is a separate department.
My lord,
they have our own policies.
My lord, I have annexed the information brochure, combined entrance test. My lord, in WPC number, my lord, 3866. Item number 56.
My lord, that part will come in provided the challenges are, my lord, amendment of 2025. He will have to say that, my lord, why this year it has not been inserted in the amendment, though, my lord, this particular other colleges are, my lord, continuing.
At page 72, my lord.
That he has withdrawn.
Relevant relevant portion at page 72.
Which one?
My lord, first one, that is point number 9, close 9. 5% seats in BTech, BE courses in the government engineering colleges of Assam are reserved for those students who studied from class 7 to 10 in government school under SEBA and class 11, 12 in state government school, college, provincialized colleges under AHEC. Currently, SEBA and AHSEC are merged as Assam State School Education Board. It start from.
This is regarding combined entrance examination.
Yes, your lordship.
For BTech.
BTech and BE, my lord.
B.
Not been conducted by the National Testing Agency or my lord, these are not seats of medical.
My lord,
education, not issued
my
by the
lord,
health department.
My lord, in addition to that, my lord, my learned friends again and again submitting that the counseling is the starting, but the name, the abbreviation of NEET is that National Eligibility Cum Entrance Test. If the entrance test is the test for admission into MBBS course, which has been initiated by the NTA, then how can the state authority can claim that only the counseling is the beginning for admission into the MBBS BDS courses, my lord? It cannot be, because, my lord, that is the subsequent stage, not the beginning, my lord.
That I pointed out.
That entrance test is the beginning, my lord. Otherwise, my lord, the state authority has issued notice in the year 2017 itself that from that year and onwards, they will not going to conduct any entrance test, my lord. In this year also, there is no any separate entrance tests for state quota seats, my lord. That is combined entrance test. Then that is the
talked by the central government, my lord, way back in 2017, my lord.
Comment is different, that is different thing.
No,
but
Union government has given, it is the MCI who issued the regulation, madam.
Yes.
They are not the authority to take that call.
That's why I'm submitting. That's why I'm submitting that that is the entrance test, and because of that, that is the initiation of the admission process, not the counseling. If the state authority, if the authority can allow anyone to participate in the counseling process without appearing in the NEET, cannot. Who have successfully got their place in the merit list in the NEET examination, they are only the persons who have called for the counseling, my lord. They can only apply for counseling, not by any other persons.
Lastly, madam, we have filed a affidavit in opposition. I will just refer to the paras, madam, lordship may have a look at that, madam. All this, whatever I have submitted is there in the affidavit.
And otherwise also, my lord, the law is settled, my lord. It is also, my lord, observed by the full court, Constitution bench of Apex Court, my lord. In this regard, I like to hand over a judgment, my lord. My lord, paragraph 7 at page 11, my lord. It is observed that the law is settled that after commencement of the recruitment process, the eligibility criteria is not to be altered because candidates, even if eligible under the altered criteria, might not apply by the last date under the belief that they are not eligible as per the advertised criteria. It is relied upon Shankar K. Mandal versus State of Bihar 2003-9 SCC 519.
No, this regarding the service letter. So far as the medical admission, my lord, the information bulletin is the main thing, my lord. It is not in dispute that, my lord, on the day of counseling, one will have to have the acquired qualification.
My lord, law is settled.
Yes, my lord. This, where, my lord, whether this has been passed in the, my lord, relating to NEET exams and counseling, my lord, relating to one para, my lord. It is not in dispute, my lord, that on the day when the counseling will be held, my lord, the petitioner will have to have the eligibility criteria prescribed under the regulations of the state, my lord. There is no dispute. Just because his name is there in the rank list, he cannot claim a seat under the state quota seats. If that is there, my lord, I have nothing to say. We would not have, my lord,
My lord,
argued for so many long,
I
such a long time.
am not claiming any
It's the third
seat
day we are-
directly as I have qualified in the need. I want to participate in the counseling
But you
process
will see the-
and to got the 5%
Okay,
results.
let us close the chapter.
My
Yes,
lord,
Your Lordship.
Otherwise, I'll adjourn the matter some other day.
Yes, Your Lordship.
This is regarding, my lord, recruitment of judicial assistant, my lord, not, my lord, medical.
Okay, Hart, Mr.
Only thing, my lord, the affidavit I have filed, my lord, in WPC, lordship may have a look at that, my lord, at the time of passing of the judgment. 4004/2025, there I have filed the affidavit. That will cover both the.
They will cover both the cases.
My lord.
They will cover both the cases, isn't
It
it?
will
Hart,
cover-
Mr.
Yes, covered both the
Hart,
cases.
Mr. M. Sekiel and counsel for
7 and
the
8, my lord, will continue.
petitioners in both the cases and Mr. B. Gogoi. Mr. B. Gogoi, you are the additional AG,
Yes, sir.
additional advocate general for the respondents.
Well, may I just refer to the paras so that you can directly pinpointing the paras. It's a long affidavit, my lord. The
I'll
11
go through
paras-
it. I'll go through it.
My lord. 7, 9 and 11, my lord.
Yeah.
Relevant. I have applied, sir.
I have replied in this, in my replies to my lord.
Orders to be passed separately. Just that, it doesn't record. It's not CAB. Later on, we'll type. You can show it as disposed.
Obliged, Your Lordship.
One judgment, my lord, he has referred to. I will also place it. My lord will kindly record it 2023 3 SCC 773. Para 82. Regarding, my lord, on the last date of, on the date of consideration, my lord, the prevailing rules will have to be applied. It says, my lord, 82.2. It is now a settled proposition of law that a candidate has a right to be considered in the light of the existing rules, which implies the rule in force as on the date consideration takes place. Consideration will take place at the time of counseling, my lord. Okay. It is, my lord, 2023 3 SCC 773.
You get a printout. Keep this also in sync.
Obliged, Your Lordship.
Okay.
Lordship, there is a tactical mistake regarding the name of the petitioner in the index. So I may be allowed to rectify the mistake after that list
Which one?
index. It should be Rokib Uddin Ahmed, but the tactical mistake is Robik in the index.
You'll have to file an application. As paid for by the Royal Council for the applicant. That is stands adjourned for a week to enable her to file application. Seeking rectification of certain typographical mistake in the first title of the IA. List again after a week on a date of expiry registry. Mr. B. Gogoi was here. Review petition.
Some other thing, my lord.
What is to be done? What was the reason for your review? Back wages?
Not aware of.
You have forgotten. You got a stay order, you have forgotten.
For the day, man. Let it do next week. Probably of the NHM. Man.
NHM,
I'm sorry, man. We have missed the matter. Can you do it next week?
not next week. Court will not be available next week.
It is a convenient matter.
Maybe in the first September,
Last.
a date in September.
The interim, if it is there, maybe continue.
What to do with respondent number 1? He's the petitioner, I think.
Yes.
When did he take steps? By the way?
I will take first stage kind of.
Respondent number 1. What is the address? Why?
This is same one like that of the repetition one.
Increment, so Mukalmua. Village Mukalmua, Nalbari district.
I will take first stage. First stage because he is not there in the department. Only when the earlier address. Then we'll have to go for neutral publication.
Steps you have taken already, what to do? You will not reach again.
That's it.
What to do?
Then we'll have to go for publication.
Publication, that thing is better. Mr. B. Gogoi, learned. I'll record you as additional AG. Appears for the petitioner. None appears for respondent number 1. Put as petitioners. None appears for respondent number 1. Are you still the standing counsel for NHM?
Yes, sir.
Then you record the instead of additional AG, right? Learned, add Mr. B. Gogoi, learned standing counsel, NHM, for the review applicants. None appears for the respondent number 1. Stop under the circumstance. The review applicants shall cause service of notice, cause service of notice upon respondent number 1 in a substituted manner by making newspaper publication in one
local, one regular one and one in the newspaper.
in two local dailies, one local and one in English, showing the next court date as. It'll take some time, isn't it?
Yes, sir.
22nd of September. Stop. The newspaper publication as directed here and above should be done on or before
15th month. And I will file one affidavit.
No, how long would it take for you to make the newspaper publication?
We'll have to draft that manner, a particular notice, we'll have to place it before the registry. They will manage thereafter issue.
How much time? 2 weeks? 2 weeks time?
15 minutes. Before 15th of September, we will complete the process. We will publish.
No, 15, showing the date as 22nd, isn't it?
Yes, madam.
Okay. No, newspaper, let the newspaper publication be done on or before 11th of September.
Publish.
But let's I am on behalf of the respondent number 5, that is private respondent in item number 44. The matter is becoming taxless. One thing is that I have filed on the additional petition question. And the matter is that the content, the brief fact of the case is that I was appointed in the year 2019 as in charge headmaster of the school. The petitioner submitted an application to appoint him as senior most teacher as in charge headmaster. This was not considered. That is why for non-considered of the representation, the petitioner filed this petition asking to appoint him as headmaster, in charge headmaster. And actually, in the year 2019, I was appointed as in charge headmaster, which was not challenged in the petition. That is not impugned by the petitioner. Secondly, I have already been appointed as regular headmaster in the year 2024, height order dated 17 March 2024. That is why it becomes infractions.
Which item is that, you said?
44.
Item 44.
Yes.
Okay, what about the others?
My lord, the others are not connected with item 44. This is of Udalguri district and mine was Morigaon district. I don't know, my lord, why this matter has been clubbed. Though, my lord, matter relates to in charge headmasters, cause of action arising is the same, my lord.
Cause of action means the subject is same.
Subject is same, my lord, because, my lord, while I was holding as the in charge headmaster of a particular school, my lord, I have the B.Ed degree. But subsequently, one of my senior, my lord, who do not have the B.Ed degree initially, later on, my lord, he obtained by virtue of the deputation. And then, my lord, he claimed that as I am now eligible and qualified, so, my lord, I should be entrusted with the charge of the headmaster of the school. And accordingly, my lord, my chargeship had been interfered with. That is under challenge, my lord.
Now, why is it listed for orders today?
My lord, actually, it should be come up for admission hearing. And my learned friend's matter may be segregated.
Yes, well, it may be segregated.
Your good name?
N.M. Hazarika.
Mr. N.M. Hazarika. You're for respondent number 5.
5, the private spot.
How do you say it's infructuous? You are respondent number 5. You're not for the petitioner.
I am not for your case petitions.
The concerned counsel is not present.
How do you say it's infructuous? I thought you were for the petitioner.
Also consider in that petition that there is no any impugned order.
Give me that.
They are saying that I have been I was appointed as in charge headmaster in the school, but that order is not impugned. Subsequently, they submitted an application
And due to non-constitution of their representation, they are filed this petition.
Where is Mr. S. Ali? Is he here today? S. Ali is not here.
I enclosed my instance headmaster appointment order in my affidavit in opposition as last page. It is 44 of my affidavit in opposition.
Anyway, we'll record your submission and post it for admission.
Lots.
Mr. N.M. Hazarika, Learned Counsel, appearing for respondent number 5 in WPC number 3021 of 2022. Submits that the writ petition has become infructuous. However, counsel for the petitioner is not present today. Mr. A. Bhuya, Learned Counsel, appears for the petitioner in WPC number 2625 of 2021
And 52.
and WPC number 52 of 2021. In view of above, that these matters be listed in the admission column after 2 weeks on a date to be fixed by the registrar.
But his matter can be segregated.
Yes, my matter can be segregated.
Why?
Because it becomes not impersonal.
Because both the schools are different, districts are
No,
different.
let it come, let it be like this.
Mile.
Let the petitioner come, we'll hear him,
Yes.
then if required, we'll segregate and
Fine.
dispose it of also.
Obliged. Lord, may I pray for a short accommodation in this matter, my lord. This is a review petition, my lord, had been preferred. Some of my personal difficulties, my lord, could not prepare it today, my lord.
You are supposed to satisfy the court
Yes, my lord,
regarding delay.
delay, my lord. My lord, on that count, my lord, I just a week's time, my lord.
Mr. A.R. Bhuya, Learned Counsel for the petitioner, prays for further 1 week time
Mile.
to address the court in regards to the point of limitation in terms of the last court's order dated 26/6/25. Mr. A. Pugan, Learned
Counsel for the
Counsel,
elementary education.
Standing Counsel, appears for the Elementary Education Department. In view of above, list this matter in after 2 weeks on a date to be fixed by the registry.
Obliged.
My lord, here some time is required. We have already filed our appeal, my lord. If some time is required. My lord, they have filed appeal. My lord, the appeal is, my lord, is defective as shown in the, my lord, website. And matter is pending since 2004 January. Now, these two gentlemen, they are working, my lord, since 1999 to till date. And their services have been provincialized in the year 2013. Unfortunately, their service was terminated, and that has been restored by this honorable court by setting aside the termination order. Now, till date, not a single penny has been paid to the petitioners respondent here. Lordship will find the order at page 42 operative part. Order dated 1/12/2023. And operative part lordship will find at page 50, paragraph 22 million. Page 50, paragraph 22.
Mr. U. Sharma.
Madam.
So what is happening?
Appeal is pending, madam. So serial number is, madam.
Appeal is pending or defective appeal is pending? Which one?
defective. Now it is. So sometime we might have given that in the meantime, we have received our serial number also might have here.
You look into the appeal, if it's defective. Court will not give you such kind of liberty next time. Okay? Today I'm giving you some more time, but next time you must come with something, otherwise we'll have to proceed. And the appeal is preceded by delay application, condonation of delay application also, or what?
Yes, it was delayed. I'm not aware. Yes, there is delay, my lord, but sometime maybe that.
You are appearing for which respondent? You don't know anything.
Number two.
Huh?
Respondent number two, man.
Number two,
Yes.
you don't know what is happening.
My lord, appeal is filed by Andre Khatonia, my lord.
Maybe, but you should collect all the information and inform the court.
Delay is there.
Whatever it may be, see, this is a serious matter.
Yes.
Allegation is against you of having committed contempt of court. And simply saying that appeal is filed will not do. Unless you have a stay order. And Mr. Mondal says your appeal is also defective. And there is application for condonation of delay. We don't know what will happen. I'm giving you another chance. You take it up. You represent whom? Manojit Kumar. No, sorry. You represent which one? Respondent number two.
Respondent number two. Surandana Chanabal.
Director.
Yes.
What about the others? One.
5, 8 and 9.
5, 8 and 9.
5, 10.
So, what is your role?
There is no direction.
No direction to you.
There are only direction to the what it goes to the order, positive direction to the only to the secretary to the director.
Where does it say director?
What he will turn to page number.
Page 50, paragraph 20.
Page paragraph 20. Only to the director. They made party to all these purchases. Director elementary education.
No, where is that word director?
From the above point of view, paragraph number 20, madam. The respondent in the director of elementary education.
Should have been directorate, isn't it?
Because positionalization had to be done by the director. So it is only the director.
Please write down this contempt petition has been filed for alleged willful and deliberate violation of this court's order dated 1/12/2023, passed in WPC number 6147 of 2022. You just add one more. It should be judgment and order, not just order. For violation of court's judgment and order. Number two has filed affidavit also.
Yes.
What did he say? She said that appeal is there. That much.
Yes, appeal is pending. I'm intending to file appeal.
Intending to file appeal.
At that time, my lord, yes.
No, appeal has already been filed. Page 76, second para lordship will file.
Next para, say full stop. In response to the in response to the notice issued to the respondents, the respondent number 2 has filed an affidavit on 23/5/2025, stating that a writ appeal has been filed. Stop. Mr. M.U. Mondal, learned counsel for the petitioner, submits that. The writ appeal itself is also defective. And that the appeal is also preceded by an application for condonation of delay. To stop on 2/6/2025, when the matter was listed, stop today, similar submission has been made by Mr. U. Sharma, Learned Counsel. To stop unless the respondents pursue the appeal, writ appeal, which according to them they have filed to challenge the order of the learned single judge. This court would not be inclined to grant further time. To stop. Accordingly, for the ends of justice, matter stands adjourned for 4 weeks and to be listed thereafter on a date to be fixed by the registry. To stop. The learned counsel for the respondents shall inform the court about the status of the said appeal. And depending on the same, further orders will be passed as the court deems necessary. Okay?
Can it be after 2 weeks, Miller?
No, 4 weeks. I'll give them 4 weeks.
So
Let them take enough time. So that next time, if nothing happens, then we'll see.
say, well, order has been passed, Miller, with that effect, Miller. With effect from 12/1/2024.
Please take due care, Mr. Sharma. Next time we might not be so liberal. Okay? Yes,
After 3 weeks, Miller.
4 weeks. 4 weeks. 4 weeks. Next week.
Obliged.
Again, pertinent to the similar matter, Lordship. The respondent number 1 has filed Okalatnama and 2 and step is taken, Lordship, in respect of respondent number 2.
Mr. Kaushik, you are there for?
I'm praying for one.
So what is your instruction?
May I pray for some time for the
How many respondents in all?
2 less.
2. So number 2, there is no ID card returned till now.
Second time step is taken, Lordship.
Already 4 months. What to do?
Yes.
Second time you have issued no, you have taken
Second time
steps.
step is taken, Lordship.
The present director of secondary education is Mamata Hojai.
Mamata Hojai.
Can you not inform
I can.
on your part also, since
Yes.
you are the counsel also?
Yes, sir.
Inform.
Let him serve a copy to me, Miller. I can take instruction from the director also.
You give a copy. Okay. Mr. PH.
DC Nath.
Sorry,
DC Nath.
Mr. DC Nath, learned counsel appears for the petitioners. While Mr. B. Kaushik, learned counsel appears for respondent number 1 and seeks for further 2 weeks time to open instructions in the matter. To stop. Although the petitioner had taken steps on 2 occasions for service of notice upon respondent number 2, neither ID card nor answer of notice has come back. So under the circumstance, petitioner shall furnish an extra copy of the contempt petition to Mr. B. Kaushik, who shall thereafter uh, intimate the respondent number 2 about the pendency of this petition, of this contempt petition, requiring the said respondent to take necessary steps. In next para, in view of above, list this matter again after 2 weeks on a date to which expiration.
Both the cases.
How many cases? 2 cases.
2 cases, 2 cases.
Similar order can be,
Same,
okay,
ma'am.
same order,
48, 49.
48, 49.
No business.
Yes.
Here, earlier, my lord, speaking order was passed by the secretary and finding was there. And here, petitioner as received from GSC, some shall be placed before the next joint committee meeting for further verification of findings of SLC and DLC. And department shall take further steps on the claim of the petitioner for provincialization based on the findings of the joint committee. Here,
You were asked to file affidavit. Where is your affidavit?
my lord, here, my lord, the conclusion is not arrived yet, my lord, because of my lord.
Maybe, but file an affidavit saying that this is the provision, this is the steps taken by us. Although not completed, but this is what we have done. That is why we are giving you time on 21/7.
Up to date status is the finance department and department of school was about to schedule to sit jointly on 12/8/2025. But it was not happen because of due to compelling administrative circumstances.
Whatever the reason, whatever may be, you file that in the form of affidavit. That's why we gave you time.
On next day, my lord, I will-
Oral submission will not do. Mr. U. Sharma, learned counsel for the sole respondent, prays for and is given further 2 weeks time to file show cause reply. To stop, if the same is not filed by the next day, personal appearance of the respondent will be directed. List again after 2 weeks on a date to be fixed by the registrar.
May I please, your lordship, lordship may please to look in the order of this report last 6/5/2025. Till today, they have not complied.
51. Item 51, isn't it?
51. Last
Fi-
order 6/5/2025. For director to take complete instructions.
My lord, here, my lord,
compliance. All are represented.
petitioner
Have you filed Vakalandama? Have you
Yes.
filed your Vakalandama?
for the respondent number 2.
Number 2?
Yes.
Then what about number 1?
Number 1 also filed.
3 also filed.
SMPC.
3 is SMT Chisti.
Yes.
2 is also SMT Chisti. And number 1? Your name is not there, Mr. U. Sharma.
That's respondent number 2, my lord.
Direction part, page 27, paragraph 39.
Mr. Sharma, oh, you've signed.
Yeah.
Okay, you've signed number 2. Then, apart from signing Vakalatnama, what else are you required to do?
Here, my lord, the approval to place the matter in the DLC was fixed on 12/8/2025 by the district administration. However, due to training and workshop for all the inspector of schools is scheduled on 11 and 12 August by the government in the Department of School Education, the undersigned is not able to place the matter in the DLC on the scheduled date. That is 12/8/2025. That is come from inspection. Sometime may be granted.
To file your show cause for number 2. Let them all file. If you all don't file, we'll call them. Otherwise, why are you appearing on their behalf? Not filing show cause and you're just simply reading 1-2 letters like that. This will not do.
Personal appearance, lordship, there is nobody
This will not do.
to appear. Service is completed. And arbitrarily provincialized service of private respondent in the writ petition lawsuit that appointment has been set aside and the direction part is placed 27/39. And thereafter filed a writ appeal. Writ appeal was dismissed and the writ appellate court also directed to consider the case of petitioner.
Where is the order? Where is the appellate court's order?
Writ appellate court lawsuit I have not annexed, but this order lawsuit.
When was it dismissed?
Writ appeal was dismissed on 27/9/2024. Paragraph 26, 27, 28 lawsuit. Paragraph 26, 27, 28, 29.
This is filed by whom?
This is filed by private respondent. And writ appellate court also directed to take steps to appoint the petitioner as the present.
Have you served this copy to the others?
They also appeared lawsuit in the writ appellate court lawsuit by government advocate entered appearance.
Oh, that's okay. But you serve a copy.
I will serve a copy to them.
Not to the council. You serve directly to the concerned
Department.
authority, department,
Lawsuit.
and get an acknowledgement.
And I have also stated in my contempt petition also lawsuits.
Please write down.
There are 14 also the
This-
statement given.
Just a minute. This contempt petition has been filed alleging willful and deliberate violation of the court's direction. Dated 16/6/2023. Passed in WPC number 2428 of 2016. Stopped by the said order, the provincialization of the private respondent number 8 was set aside and a direction was made for provincialization of the writ petitioner. Stop against the same. The private respondent number 8 filed writ appeal number 100/2024, which however was dismissed
Two
Right.
writ appeal.
by the division bench by order dated 27/9/2024, with a further direction that the services of the writ petitioner / the contempt petitioner should be considered for provincialization. As per the relevant provisions of law. Stop. Mr. F.U. Babuya, learned counsel appearing for the petitioner, submits that despite the same, the respondent authorities have failed to comply with the court's direction. Till date. Mr. U. Sharma, learned counsel, appears for respondent number 2 and prays for some time. To obtain instructions and to file show cause reply. So stop. It is also seen that the other respondents, that is respondent numbers 1 and 3, are also represented by the respective councils. But they are not available today. Next para, considering the above position, the matter stands adjourned for 3 weeks. and registry to list the matter thereafter on a date to be fixed by it. To stop, the respondents numbers 1 to 3 shall file their show cause reply indicating the compliance of the court's direction and the steps taken in that regard. Failing which consequential orders will be passed by this court.
Need it to the lordship.
Yes.
So, office note dated 6/8/25 in respect of respondent number 1, service is not completed. But the other respondent number 2 and 3, service is completed.
I have been for two, my lord.
2 and 3.
I have only for two, my lord.
Who is paying for 3?
Only have. Yeah.
The office note says Vakalanamais file. B. Gogoi, T. Nayak, A. Chaliha, R. M. Barua. Therefore,
Non-payment of arrears salary.
no. That's not what I'm asking. Okay, contempt number 3. You are for 2.
My lord.
Then 1, no one.
Lordship, service is not completed. Neither answer notice nor etiquette is written.
For respondent number 3.
Yes, so what is your instruction?
There is regarding payment of arrears salary, lordship. So the arrears salary has to be initiated by the authorities of the education department, which is the administrative department in this matter, lordship. The direction was passed to the authorities, of the education department, to release the arrears salary amounting to 3 lakh.
Put that in the form of an affidavit and file. You also file.
Process is on, my lord. The proposal has been submitted to the secretary.
File that in the form of an affidavit, the process. Today you'll say something, tomorrow we'll forget what that was submitted.
4 weeks time.
If you submit an affidavit, it will remain in the record. So whoever's handling the matter knows what is what. That is why. Mr. A. Chaliha, Learned Counsel appears for respondent number 3. And Mr. P.K. Bora, Learned Counsel appears for respondent number 2. No one appears for respondent number 1. It is seen that notice was issued on the respondents, including the respondent number 1 on 12/6/2025. To stop, as such, office shall track the postal consignment in respect of notice sent to respondent number 1 and put up a note. To stop, the respondent numbers 2 and 3 shall file their show cause reply within
4 weeks now.
3 weeks from today, indicating the process, indicating the compliance of the court's direction and the process undertaken by them. Next para list again after 3 weeks on a date to be fixed by the registry.
Bless.
That is all. My lord, this my lord, has been filed, my lord, 1974, my lord, seeking amendment, my lord, in the writ petition, my lord. Amendment in the sense, my lord, during the pendency of the writ petition, we are subbed with some document under RTI, where it shows that, my lord, the respondent number 5, he was, my lord, of higher secondary in 2018, my lord. But on the basis of the document, my lord, he submitted before the authority that she passed her higher secondary in 2002. In fact, she was, she is the matriculate in 2002. And her appointment has been shown as 1990, in which, my lord, date, my lord, he was even non-matric, my lord. So in that way, my lord, her provincialization is, my lord, we are challenging in this writ petition, my lord. So, my lord, your lordship will kindly see that, my lord, we have received this, my lord, document under RTI, my lord, page 15.
You are the petitioner, isn't
I
it?
am the writ petitioner here, my lord.
Who's the respondent?
Respondent number 5, my lord, her service has been provincialized. In
No,
fact, my,
have they appeared?
her name shows, my lord.
Have they appeared?
Yes, my lord. In fact, her name shows, my lord.
Mr. Pegu,
Yes, my lord.
you are for?
Department, my lord.
Any objection to the IA?
No, my lord.
What do you want to show by this IA?
My lord, in fact, my lord, I want to just incorporate these facts, my lord.
Which one?
Page 15, my lord. In fact, this was not before the authority, these documents, my lord. And as per this document, my lord, she is, my lord, her matriculated in 2002, my lord. But he, my lord, submitted document before the authority showing that she passed her higher secondary in 2002.
Give me the main writ petition, please. Somebody had appeared for number 5.
Yes, yes.
Who is that?
Her name, my lord, appears. Yes, yes. Her name is also there, my lord. She's shown Z.A. Asadia.
Where is the Wakala number? Just check the second file. This is a Wakalatma of the petitioner. Oh. Okay. So we'll allow your application.
Awesome.
Third, Mr.
J.C. Bora.
J.C. Vora, learned counsel for the applicant who oblique writ petitioner who submits that by filing this application, the applicant seeks the amendment of the writ petition in the manner shown in paragraph number 5. Only 5, is it?
In fact, my lord, that is 5 and 6. That is 5 and 6.
How do you say 6?
In fact, my lord, in my IA, that is a para 11A and 11B.
There is no paragraph 11.
In fact, in my IA, my lord.
In your IA, there is no paragraph 11. The last paragraph is paragraph 7. Which IA you're talking about?
That is IA, my lord, 1974. In fact, some mistake is there, my lord. In fact, chronologically, my lord, after 5, my lord, 11A and 11B is, my lord, mentioned. My lord. Because in my writ petition, after 11, my lord, this has to be incorporated.
Oh, that is the paragraph which you seek to incorporate.
Yes.
This is not the paragraph of the application.
Yes.
So that distinction is there.
Yes, sir.
You are saying as if the application contains 11 paragraphs.
Yes.
So the proposed amendment,
Yes.
the entire proposed amendment is contained in paragraph number 5.
Yes, ma'am.
Correct?
Yes, sir.
What did I say? In the manner shown in paragraph number 5 of the application. The learned counsel submits that the amendment is required for effective adjudication of the writ petition, and that the same will not change the nature and character of the writ petition. Mr. G. Pegu, learned standing counsel. Which standing counsel? Elementary Education Department. Appearing for respondent numbers 1 to 4. Has no objection. to the prayer. Stop. No one appears for respondent number 5. Although respondent number 5 has engaged a counsel, the name is shown in the cause list. Next para, in view of above, upon considering the submissions made and the perusal of the application for amendment is hereby allowed. IS stands disposed of. Then in the main, please write, in view of the order passed today, 7/4 of 2025, allowing the application for amendment of the writ petition, the petitioner shall file a recast petition within
Within 1 week.
within 1 week from today, after furnishing requisite copies to the learned counsels for the opposite parties. This matter again after, the matter again after 2 weeks. On a date to be fixed by the registry.
And DPO.
No one appears for the petitioner when the matter is called. List this matter again after 2 weeks on a date to be fixed by the registry. The learned counsel for the petitioner will have to satisfy the court about the delay in filing the review petition in terms of the last court's order dated 26/6/2025.
May I proceed, Lordship? Lordship, in this matter, we have taken steps to all and also regarding the justice service, we have also filed an affidavit. My lord, steps has been completed.
Have you filed the affidavit?
Yes,
Where is the affidavit?
Yes. 8 August 2025. I received copy on 27, page number 27.
Dusty notice on whom? Respondent number 3.
3.
And what about the others? You have 4. You have 1 and 2. And number 3 is?
Yes, Ahmed.
Mr. S. Ahmed, learned counsel for the petitioner, submit that. As directed by this court, Dusty notice has been effected on respondent number 3. And an affidavit has been filed enclosing the acknowledgement of respondent number 3. On perusal of the same, notice upon respondent number 3 is accepted to be complete. Mr. S. Das, learned standing counsel. Higher education appears for respondent number 1 and 2, while Mr. G. Sharma appears for respondent number 4. Are you going to file anything? And pray for how much time? 3 weeks time to file counter affidavit. Prayer is allowed. List the matter again after 3 weeks on a date to be fixed by the registry. Stop in the meantime, respondents to file their counter affidavit.
Interim order may be continued.
What is the interim order?
Status quo order passed 21/7.
Okay. Till then, till the next date of listing, status quo order passed earlier shall continue.
My lord.
Lordship, I don't know if my case still survives.
Is it so?
I don't know because it is a 2016 matters. Now they have filed affidavit. In the affidavit, they stated that the list has been withdrawn, the notification has been withdrawn, but no such paper has been given. I was in the category of 10% reservation for the retired school teachers.
For appointment of which post? Against which post?
TET teacher.
TET teacher. You're claiming some
Yes.
quota,
Quota.
reservation quota
10% quota.
for
Retired school teachers. Retired school teachers, 10% quota.
retired school teachers.
Lordship. Then in the advertisement, it is there. It was there. At page 15. Criteria. Reservation, relaxation.
Page number 15.
Lordship. That is at 6, reservation 6. There shall be a reservation for the SC, ST. I am SC also. SC and daughters of retired teacher.
You just said something has been withdrawn. What is withdrawn? Reservation is
In the
withdrawn.
affidavit that said notification has been withdrawn, at this stated in their affidavit, but that document has not been given. So therefore,
Where is that?
at page 2, it is pertinent to mention that in the meantime, the government of Assam has withdrawn 10% reservation benefits granted to sons and daughters of retired employees of government employees, right? Notification dated 4/7/2016.
Page 2
Page 2,
of the affidavit
affidavit,
filed by respondent number
filed
2.
by respondent, Director, Elementary Education.
Page 2, which paragraph?
Last, it is pertinent to mention at page 2, last bottom.
Yes, Mr. Kaushik, anything
That policy has already been withdrawn by the government.
by which order, by which notification?
The notification will have
You produce it?
4/7/2016. I'll produce.
You produce it.
Secondly, the second clause was given, second statement was there. The petitioner scored more marks than that of respondent number 4 and 5. No statement has been given. Whether they have been appointed, I was denied. No statement has been given in the affidavit as to why they were appointed, not me. It is always that affidavit is a hopeless one, in fact. Nothing has been disclosed.
Okay, Mr. B. Kaushik, learned standing counsel. This is what elementary or elementary education department shall produce the notification dated 4/7/2016. By which it has been claimed that 10% reservation benefits granted to the son oblique daughter of retired employees in government employment has been withdrawn. As stated in paragraph number 5 of the affidavit in opposition filed by the respondent number 2 on 1/8/2019. This matter again. When? After a week? After 1 week, on a date to be fixed by the registry.
This case, my lord, by order dated, my lord, 25/6/24, passed in IA, my lord, matter is likely to be listed for final consideration. Matter related to, my lord, constitution of school management committee. Today, my lord,
Today is difficult. It takes some time.
My lord, only one thing may be considered, my lord, can you peruse the order date 12/2/2024, my lord?
Yes.
In in second paragraph from last paragraph, my lord, and in second paragraph, my lord, last 5 lines. Accordingly, till the appeal as filed by the petitioner on 12/2024 is disposed of, the approval as granted by the district implementation officer, right, so and so, to the constitution of so and so, shall be kept in abeyance, my lord. That is, my lord, of my simple prayer, my lord, whether the director has disposed of the appeal or not, this is required, my lord. On this ground only, my lord, the impugned order has been stated, my lord, kept in abeyance, my lord. So director may be directed to produce the disposal. No, order to have appeal filed before the director. My lord, this is the appeal. Appeal filed before the director, my lord, and the order passed by the DO has been kept in abeyance.
Yes, what is the instruction?
Yes.
I have to take exception.
Appeal is enclosed here.
Yes,
Yes.
my lord. Appeal is here.
is 54, my lord.
Okay, please write down Mr. G. Pegu, Learned Standing Counsel. Elementary Education Department. Page number 54.
Before of the petition.
Shall obtain instructions with regard to the status 12/1/2024. Who has filed this?
Petitioners, my lord.
Filed by the petitioners. After that date, we could just put in a bracket, next year 10. Filed by the petitioners by the next date. Having regard to the observation made by this court in the order dated 12/2/2024. In the second last paragraph. List again after 1 week, 2 weeks, on a date to be fixed by the minister.
Well, if possible, my lord, date may be given, my lord.
They will give the date.
Is your lordship, my lord, this matter relates to compassionate appointment, my lord, and it is covered by the final order dated 3/4/2025, passed in a series of similarly situated cases, my lord. This is the order, my lord, your lordship may kindly see the last sentence. Yes. Last sentence to sir. This is a pending case before this honorable court since prior to issuance of the notification, my lord, which was challenged in series of cases. The last sentence, my lord.
Mr. Bora, what do you say? Is it like that? But what is the facts of the case?
Facts, my lord, here the petitioner's father was missing since 25/2014, my lord. Missing, my lord, and she has applied on, my lord.
No, for missing person, is it applicable? Compassion
Yes, my
appointment?
lord. Yes, my lord.
Applicable.
Yes, she has applied after 8 years.
After 7 years.
And she, yes, she has applied, yes, on after 8 years. Her application is page 21, my lord. This is dated 18/7/2022. Page 21, my lord, this is her application. And at the top, my lord, left side, there is my lord, your lordship may kindly see the office note. It was forwarded by the authority. Please put up for submission before DLC.
at the top left, my lord. So thereafter, the preparation was going on to submit before the DLC, my lord. And there was an official communication, the next page, Annexure B. There was a decision communicated by the authority. The authority requested to examine all pending cases pertaining to compassionate appointment and submit your DLC proposals, if any, on or before 28/2023 without fail. So our process was going on. In the meantime, this impugned office memorandum was issued on 18/9/2024, my lord. So, my lord, subsequently, my lord, series of writ petitions were filed and this judgment was passed, my lord. And the petitioner's case remained pending, my lord.
Lordship will kindly turn to page number seven, my lord, of the petition. It clearly stated that on 25/2014, they went missing. And as such, my lord, death certificate was issued on 2/6/2022. There is a notification 2017, my lord. Person 14 September 2017, my lord. Compassion appointment. You filed an affidavit. Lord, I filed an affidavit. Was paid for by Mr. S. Bora. How much time? 2 weeks time?
Pending, my lord. They have
2 weeks
taken
time.
time several times, my
He
lord.
will be entitled to the retirement, he will be entitled to enter full payment without any 2 weeks time is granted for filing counter affidavit.
Then with this direction also, your lordship may dispose of, my lord.
No.
Because
Let
it
him
is
file the
pending.
affidavit.
Earlier also, my lord, they did not file any
No.
affidavit. It is pending since
Lordship,
May
now it took
2000.
time. Your documents are too sketchy. 2 weeks time, I thought I will file. List again after 2 weeks on a date to fix by the registry. You write Mr. Bora, standing counsel BTC. Okay.
Here, my lord, during my service period, I was applied for provincial service, found eligible, but that was not done. In the meantime, I retired from service. So I have filed it, my lord, to give retrospective of my service provincialization, my lord, from the date when I was found to be eligible. And my lord, national benefit, my lord, for that period. Thrice, my lord, the state was, they have taken time for filing affidavit, my lord. Headmaster has filed affidavit. He is supporting my case, my lord, but the state affidavit is necessary. 3 occasions they have taken time.
Yes.
No affidavit is coming.
And instruction is awaited, my lord, some time maybe.
My lord, last date is, yes, date next time they will be provided, but if not filed, my lord, personal appearance will be responded, that may be.
My lord, it is a matter of 2024, my lord.
It was filed on August. Mr. A.I. within learned counsel appears for the petitioner. And Mr. U. Sharma, learned standing counsel. Secondary education, is it?
Secondary. Can it be? Can it be?
4 week, no problem. That's a person may be there. That if not filed, well, already thrice they have taken time. I have no objection. They may be given 4 weeks time.
It is the secondary matter.
Second time, first time, third time. We are interested with the affidavit only. So whatever time you take with the responsibility so that you assure that the court that you will be filing it, that's all. Mr. Sharma, you're not confident with 3 weeks. You are confident with 4 weeks. Why?
My lord, there are so many matters, my lord, pending before that.
I know, so will matter. So many councils are there. You handle it is up to you how you handle your thing. further 4 weeks' time is granted. With an understanding that counter affidavit will be filed by the next date. List the matter again after 4 weeks on a date to be fixed by the registry.
Personal clearance.
We'll see. I have meeting. After rice. The other matters, I think we'll give you a date. Courtmaster will ensure will give that he'll.
In respect of 37, my lord, here I have challenged the departmental proceeding. I am waiting for a short time, and they have not filed anything.
Okay. We'll see what can be done, okay?
Item 34,
Any interim order is there, you tell also, then according to the.
item 34 with urgency, this is fourth litigation arbitrarily denying the benefit provincialization in spite of clear directions of the court. They come with the wrong order, the same contention, same stance, again passed. Due to get right for the contempt proceeding. That's why again I have to check.
Okay, you'll get,
Lost date and date for fixing a short date.
just come. Just come. See, you necessarily not required to give a date. You can say after 1, 2 weeks or 3 weeks, depending on the requirement. Okay, if there's an interim order to continue. So you can also mention that due to positive effect, the matter will undertake, you know. The matter will step after such. Okay.
Minus over Article 33, petitioner service or subsequently concern, that may be fished by.